My apologies, that got ahead of me. Good evening, and will the County Services Committee please come to order? Good evening, ladies and gentlemen. Tonight, we have asked Justice Ricker if he would lead us in the prayer and the pledge. Justice Ricker.
If you'll bow your heads. Lord, we ask you to watch over the people of Washington County, especially our first responders who are working in this winter weather, and if you would help us to make decisions for the betterment of our county. In Jesus' name we ask, amen. Amen. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Justice Ricker. Is there a motion to adopt the agenda? I have a motion by Justice Ricker and second by Justice Slimming. All in favor? Are there any? Oh, I'm sorry, I didn't see. One moment, please. Justice Bruns?
I make a motion that we take number 9 off the agenda. It was voted down last month, or last Thursday. And I think the appeal process, the attorney can tell me differently, but I think the appeal process is that we go, if we vote it down at the quorum court meeting, it has to go to, or they can appeal it, but they have to appeal it to the circuit court.
I understand that, but I believe it needs to stay on the agenda for discussion.
You want me to speak to it?
Just one moment. We're going to have County Attorney Lester address the issues, if you would, please.
So your ordinance requires that you pass an ordinance affirming your decision. So what happened the last time is the ordinance to pass the CUP failed, and so that doesn't get filed. There's not a number. Under your own ordinances, you have to pass an ordinance that that says what your position is, that memorializes. That's what your ordinance says. It says the quorum court shall pass an ordinance that memorializes its decision. And when you don't pass an ordinance, then that ordinance never gets filed. That ordinance doesn't exist. And so to memorialize your decision, you need to pass an ordinance denying the CUP. That's why it's on there.
Are we okay?
No, I did totally disagree.
Well, whether you disagree or not, that's the law, Justice Bruns.
I haven't seen that law, I'm sorry.
Well, we're moving on. Justice Koger?
You have a motion. You have a motion.
Wait a minute, I'm sorry. We have a motion and a second to remove item number 9.
Where was the second? I'm sorry.
You're right, there was a motion. Is there a second? That motion fails for lack of second. Thank you. Now I do believe I have Justice Koger. Yes, thank you. One moment, please.
Thank you, Madam Chair. I've had lots of people call me about this, about that item number 9, and I understand what Attorney Lester just said, but why is it that we have to have, when we have a CUP, that we have to vote for and against, but we don't vote for and against on other ordinances? That's what I'm trying to understand.
Because you have passed an ordinance in the past, not necessarily maybe you sitting here, but this quorum court that says that the quorum court shall memorialize its decision by ordinance. So you must memorialize your decision by ordinance. That's the only reason.
I don't get it, but okay.
Perhaps we can have a conversation after and find out what it is. Is that okay? Okay, thank you. I have Justice Massengale. Yes?
Yes,
One moment, please.
Yeah, sorry, I tried turning it off. I got the same question. Every time we deny a CUP that was approved by the planning commission, are we gonna have this twice, or should that original vote against it been an ordinance? Or did we make a
So
mistake?
as long as you have a provision in the planning code, as there is now, that says that the quorum court shall memorialize its decision via ordinance, then you will have to pass an ordinance. So either you remove that provision, and then if an ordinance just fails, it fails. But as it stands now, because of that provision, you have to pass an ordinance. So those are your options. And at this point, you got to pass the ordinance because you haven't amended the planning code. That amendment would have to go all the way back to the planning board and work its process. So for this, I would suggest you go ahead and memorialize your decision by denying the CUP, and then we're done with it. That's it. It's not real difficult, really.
Justice Bruns.
I don't understand why we're doing it on this one. We don't do it on others.
You do it on every single one.
No,
Every
we
single
don't.
one. Huh?
No, we don't.
No, there was no first reading of this one. So at the quorum court, you can do all three readings at the quorum court, but it was never moved, it was never read for the first time. And yes, every CUP that's ever failed has an ordinance denying the CUP, as long as there's been CUPs in Washington County since 2006.
I have Justice Lemming.
Well, a lot of these is handled normally at quorum court nights. That happened at a special called meeting. That's kind of why we're having to add this and finalizing what we did. Is that
Well,
correct?
because the quorum court never moved this ordinance on in a reading, so it has to be read 3 times. I thought it brought it on here to kind of have this discussion so that we didn't have a bunch of people wondering why we were having it at quorum court. And so you've got to pass the ordinance denying it to memorialize that, and so.
Is this in the new freedom package that y'all just passed?
Yes, but it's been in, it's part
It's been in
of
the CUP process forever too.
Yep.
Okay, thank you.
Justice Washington.
So I understand what you're saying, and I think maybe to simplify it for the group, what he's saying is that if we vote no on approving an ordinance, that is not the same as denying the ordinance. What memorializes it is the denial, the actual action that we want to take. So I understand that it could be a little confusing, but those two things are not the same. So what we did was there was a motion to approve, and then it didn't get a good vote. So now we just need to say, it's still the same action, but we're just saying, hey, we're denying it. So it's nothing different, it's just the wording is different because denying something is not the same as not approving, if that simplifies it. And if I'm incorrect, just correct me.
No, that's correct.
Justice Koger.
Thank you, Madam Chair. Okay, my question then is, and also I was asked this question, why is it on county services? I don't remember a CUP ever being on a county services meeting.
Typically, it would not be on a county services meeting.
It wasn't.
It originally, the reason it was on here is so that you all would understand why it's gonna be on the quorum court meeting, right? So we can have this discussion. Hey, we still have this ordinance out there, it needs to be passed on, it needs to be put on the quorum court agenda, so that's why it's here. It was only for informational, so we could ask all these questions, and there wasn't more confusion at a quorum court meeting than there is right now. That's why it's on here.
Okay,
That's
thank you.
why I asked Mr. Allen to put it on.
Okay.
I have Justice Lyons.
And I think, Counselor, you just answered mine. Tonight's vote only moves it to the quorum court.
That's
Doesn't
correct.
pass it or anything.
No.
It's like everything we do out of committee, it's a motion to pass it to the quorum court, whatever.
That's correct.
I have Justice Pond.
Yes, thank you, and I'm supportive of doing this way. I recall not too long ago at a meeting, we had one of these where we had a motion to deny and a motion to approve. and we were discussing and voting on both of them at the same time, which was very confusing to the public. And
Well, they're technically not motions. You don't get to the approval part of an ordinance until after the third reading. It was their request. We always term them as motions, but it's really a request for one thing to be read for the first time.
I'm all for doing whatever we can to make this where we're sure it's legal when we're through with it. So I appreciate what you're doing. Thank you.
Thank you. Now, I have a motion and a second to adopt the agenda. Are there any additional amendments to the agenda? All in favor of adopting the agenda, say aye. Aye. All opposed? Aye. The agenda has been adopted. Moving on to item number 4 is the chairman's report. Take off my glasses so I can read. For anything to work well, it takes leadership. During the past few weeks, Washington County experienced the harshest winter weather this year. I am pleased to report that under the leadership of Judge Deakins and the exceptional dedication of the employees in the roads department, county roads were well treated and maintained during the winter storm. The primary concern of the roads department employees was to ensure the safety of Washington County citizens. These individuals worked tirelessly around the clock, focusing on keeping the roads safe and accessible during the winter storm. I have often said that it is not only about the people served, but it is also about the people who provide the service. Numerous employees from various elected officials' offices demonstrated their commitment by braving the winter storm conditions and reporting to work, ensuring uninterrupted services to the citizens of Washington County. Ultimately, for anything to work well, it requires strong leadership. Here in Washington County, we are fortunate to have excellent leaders guiding our community through challenging times. And I think the roads department men need to be recognized. If you see them out on the roads, roll down your window, slow down, and tell them thank you for a job well done. But I want to say thank you to our roads department guys very much. They work tirelessly. Okay, moving on. Item number 5, the juvenile detention report by Director Tinsley. Good evening, Director Tinsley.
Good evening, Madam Chair. And good evening to the County Service Committee members. I'd like to share our Juvenile Detention Center monthly report for January 2026. This report covers 28 days of data. In January, we had 24 intakes, and the average length of stay was about 14.60 days. Our average daily population came out to just over 14.25 residents. The most common charge for intakes was terroristic threatening, felony at 6 cases. Of the 24 intakes from Washington and Madison counties, 11 intakes were from Division 8 and 12 intakes were from Division 3. We also had 6 transports during the month of January. 5 were handled by the Juvenile Detention Center and 1 was done by the Washington County Sheriff's Office. That concludes the January 2026 report. Are there any questions that I can answer at this time?
I have Justice Hires.
Thank you, Madam Chair. You may not be able to answer this, but I am so curious because I have never seen inciting a riot on one of your reports.
Yes, ma'am.
What can you tell us about that?
Well, as much as I can get into it, Justice Hires, a lot of times we have young men, young women, they go to treatment facilities. And a lot of these children are from out of state, from Texas, Ohio, what have you. And so they kind of band together and and try to incite a riot at some of these facilities. And so that's what happened this particular month. And so that's why terroristic threatening was at 6 and inciting a riot, because we had a couple of young ladies come in all on the same charge. Yes, ma'am.
Young ladies.
Yeah, thank you, just morbidly curious, thank you.
Yes, ma'am.
Justice Lopez.
Yeah, I think I might share that morbid curiosity. I've never seen obstruction on here either. Was this corresponding to the same incident that they were charged on?
Yes, sir, it was.
Okay.
Yeah, yes, sir.
Understood. Thank you.
Any other questions for Director Tinsley? I have Justice Koger. Oops, excuse me, I'm sorry. Would you please do that again? Thank you.
Thank you, Madam Chair. Yeah, I have just a couple of things. First of all, I'm glad to see that the number is down the end of month considerably from what it was at the first of the month.
Yes, ma'am.
And also, I want to thank Director Tinsley for the information he gave about comparing 2004 and 2024 and 2025. I know you put a lot of work into that report, and I really appreciate it. It's very informative. I did have one question.
Sure.
But I'm still going through it. But if I understand it correctly, during that time, only 4 children or juveniles were charged as adults. Is that how you?
Yes, ma'am,
Okay.
and that was in 2024.
24, okay.
I believe so. I'm sorry, I'm trying to go through my notes, but yes, ma'am. We had 4 in 2024.
Okay, well, again, I thank you so much.
Yes, ma'am.
Likewise, thank you for bringing that to the forefront, Justice Koger. It was really good to get that report, and we appreciate it very much.
Yes,
You're doing a
ma'am.
great job.
Thank you, Madam Chair. And Justice Dennis, it took a while, but, you know, as promised, that we were gonna try to start doing our annual report every year. It was just when we had this, when we went to a new right track system, a lot of data got lost, so we've been having to hand do everything. So it was consecutive days of just trying to make sure that we had accurate numbers from the Division of Youth Services and other entities. And so next month, we will try to have a social work all annual report that's gonna reflect how many kids went to treatment, how many kids went to DYS, and so it's gonna break down some more numbers in a different department that's in JDC, because they do a lot of assessments and they work around the clock to make sure that these kids are getting the mental health services that they need. And that's also the court making those referrals to get SWIP assessments for these young men and women. So we'll just appreciate everyone that helps us out.
Thank you, Justice. Dennis, any other questions? Seeing none, thank you, sir. Have a good evening.
You too, Madam Chair. Thank you.
Next on the agenda is item number 6, the Sheriff's Report, and we have Sheriff Jay Cantrell. Good evening, Sheriff.
Good evening, Madam Chair. I'll start with this. This is a representative sample of the mats that our detainees sleep on. This is a salesman's representative sample. I'm going to pass this around, and so you can kind of see what, when we talk about them sleeping on their bunk or off their bunk, this is what they sleep on.
Now, since you brought that up, is the bunk itself a metal frame down at the bottom is what you put the mattress on,
Some are metal and some are concrete.
and some are concrete?
Yeah, some are concrete, elevated concrete platforms, and then some are metal bunk beds, metal frame bunk beds.
But you know, what is it, the support of the bunk itself is what they put the mattress on,
Yes, it's a piece of flat steel,
flat steel.
yes.
So no wonder they want to sleep on that thing. Anyway, thank you.
All right, you've got the report in front of you. You can see the calls for service for our Enforcement Field Services Division is up a little bit. We've kind of seen a bit of an increase in that, but we've seen a bit of an increase in our population also, so nothing surprising about that. Detention intakes up a little bit over the prior year. We've sent just a tick fewer, just 3 fewer to prison over the same time period last year. You can see our average daily high count is down a little bit. We can attribute that to the average pretrial numbers, which are down over 100 from this time last year. So, anyway, the report's there, and I'd be happy to answer any questions anyone might have.
I have Justice Coger.
Thank you, Madam Chair. Sheriff Cantrell, thank you for bringing that. It looks a lot different than what I saw the last time I toured the jail, so you've upgraded.
Well, yes, those are the ones that we're currently purchasing. Now, there are still some old ones there, and after a year or so of lying on that, it's going to be a little flatter. But that's how they start out.
Okay, well, I appreciate that.
Yes.
So I have my regular questions then.
Yes, ma'am.
Starting with the 309s. How many 309s do we have?
Currently have 35 309s,
That's
16 males and 19 females.
Okay, 19 females, okay. What about COVID and quarantine?
No COVID today. We haven't had COVID since January 12th. So, yeah, we're fortunate to have some flu and, just the winter sniffles and colds and stuff like that, but no COVID.
So people with the flu, are they under quarantine?
Well, yes, we keep them separate just to try to help from spreading throughout the detention population.
And how many did you have sleeping on those mattresses or whatever they are on the floor last night without a bed
Last
or a
night,
bunk?
168.
Ooh, okay. What about federal prisoners?
Federal, we have 79 U.S. Marshal and 5 immigration. That was as of 2 o'clock this afternoon.
Okay, and I haven't asked about staffing in a few months. If you could bring us up to date on the staffing for both the detention and the enforcement divisions?
Yeah, enforcement, we've made some inroads. We're only 3 deputies short on patrol and 1 in dispatch. We have had one young lady that we hired from Siloam Springs, but her heart was just still at Siloam. She wanted to go back, so she left. So we have 1 opening in dispatch, and we have 33 jail openings. 13 of those openings are funded positions. Then, as you recall, during the budget, we have 20 that are unfunded. Once we get those 13 funded positions filled, then we'll come back to you and say we'd like to fund a few more of those unfunded. But we still got 13 funded ones, and seeing an uptick in applications, which is encouraging. So we're hopeful that we can make some inroads into those detention openings.
It must be hard when like yesterday, you had 740 people in the jail, and you're short 32 on detention? Is that correct?
That's correct, yes.
But how do you staff that? I mean, that's got to be hard.
Just like everybody else that works in their office and works shorthanded or works extra, it's like the road department did over the winter weather. We just, people come together and shoulder the load and get it done. There are some things that we'd like to do that we can't. Some programs that we would like to implement or maybe bring in. We don't have the space and we don't have the deputies to watch them. And they need some oversight sometimes for those programs, just to have somebody present. But anyway, we're making some progress with our hiring, so
Okay.
excited for that.
Thank you, that's all I had.
I have Justice Lopez. Oops. Would you please turn that on again?
No problem. Thank you, Chair. Sheriff, I have
Sheriff, you're going to have to I hit accidentally delete all instead of mic on.
There we go. Okay.
Yes.
Thank you, sir.
Thank you, Chair. Sheriff, I do have a question here. I just want to make sure that I'm interpreting this correct. So calls of service have gone up, detentions have gone up from year to year, but our daily average head count is lower and our pretrial is lower. So I'm taking it that either our process for processing these people has gotten quicker in the last year. Would that be a fair assessment of the situation? Or?
Yes,
Okay.
I believe that's correct. The prosecutor told me last week that his county, this county, was the busiest one in Arkansas as far as processing cases last year. That they processed a higher percentage of cases than any other county. So the judges, the prosecutor, the public defenders have all come together and realized that we had a backlog and have worked hard to bring that down. So
Thank you.
We're thankful for that.
Just one moment, Justice Massengale. I have Justice Massengill.
Yeah, thank you, Sheriff. You've answered most of my questions. Just have one more. What's the design capacity of the jail?
710 is the bed capacity. We have 30 beds at the current CRI, which gives us a little bit of help with those extra 30 beds. But we lost 96 beds during our construction phase that they had to take down to add the additional COVID mitigation beds on. But we'll get those back July or August, we think. They feel like they're ahead of schedule. But, you know,
That'll bring you back up to 710?
710 plus the 30 that we have at the CRI, so that'll take us to 740 beds. The counties, as a rule, probably should operate about 80% of their max as their maximum operating capacity, so that should put us about, 620 or so for operating capacity, but we're a good bit over that.
Okay, thank you.
Yes, sir.
I have Justice Bruns.
Yes, I heard about the road department. We're very proud of them. But I guess all your people were home in bed asleep.
Well, no, not hardly. We're
Yeah.
we're a 24-hour day, 7-day-a-week operation, so we were out in the middle of it, just like all the other emergency responders. Fortunately, we didn't have any crashes. Nobody ran into us. We didn't run into anybody else. Didn't get any cars in the ditch. So it was a good event for us as far as no damage to any of our property. Helped a lot of people get home and get back to work. Just answered our calls for service that came in, worked a lot of accidents, helped state police out on the interstate a lot. So.
Well, I heard from a lot of people in the south part of the county that were very appreciative of your agency for all their help, so we dearly appreciate you.
Yeah, thank you, sir.
Are there any other questions for Sheriff? I think that's it. Thank you.
Thank you, Madam Chair.
Have a great evening.
Yeah, yes.
Next on the agenda is the, oh, I lost my agenda. Is the CRI Returning Home Update by Nick Robbins. Thank you.
Good evening.
Good evening. Good to see you.
Yeah, appreciate the opportunity. So just kind of give you some highlights from the first, from 2025. For CRI, we were able to serve 129 individuals. We had a number of partners come alongside us, kind of wanted to share what some of that looked like. One of them is becoming a big partner is Cross Church. They actually did an event for the families of those that we were working with in CRI. So the mothers and guardians and children were able to all attend an event, and they got Christmas gifts and connected to some resources. So that was a pretty awesome and very well-attended event. As always, ERISA Health is a huge partner providing the mental health services on site. Tyson Foods has also been a partner on site as far as their team comes out and does mock interviewing and kind of preps them to get into the employment space. As well as they agreed to pay for it. So any individual that has a DUI or a DWI has to go through a program called DASAP and Victims Impact to be eligible to get their license back. So if an individual has one DASAP and one Victims Impact, it's $190 to sign up, get assessed, and then attend that class. So Tyson's actually paying for everybody comes to CRI to go through those classes. So we set up a computer space where the guys can attend for 8 hours at a time for the DASAP so the individual is eligible to get their driver's license once they get back to the community. So that was a huge blessing and a big burden off the individuals to get that done. And ERISA Health oversees it for the state of Arkansas, so they actually send a staff member to us and they assess the guys. So typically, when you're out, you just go online and you log in, and you just sit there and watch the things spin, and hopes that somebody shows up and assesses you. It could take between 15 minutes to a few hours before an assessor is available. And so knowing that they're sending somebody from the Little Rock area, she drives down every 2 weeks to assess all the individuals that are in CRI to make sure that they get that accomplished and make sure that Tyson gets that paid for and gets that done is a huge blessing for our guys. We also partnered with the Goodwill Academy in Springdale. And what that did is we used that same new computer lab to give our clients access to a number of classes, some certifications. So the different certifications is project management, so that's a Google course, digital marketing and e-commerce, data analytics, UX design, cybersecurity, IT, automation, and Python. And to kind of give you an idea, so an individual that gets signed up and goes to the academy in the community, typically. So when we were getting our guys kind of prepped and getting them excited about attending this, their staff let them know, hey, it's going to take 3 to 6 months is a typical time to complete this, these course, like one single course. And so we sat down the guys and we're like, hey, you don't have that much time. So we need to really buckle down and get these things accomplished. Our first individual completed his course in 7 days.
Wow.
And that same individual completed every single course that was available to him. He created an app, and he's got a business that he'll be launching once he gets released. And we actually are connecting him with some potential investors. We've got a lot of individuals with the right guidance have so much potential, and it's a real honor to come alongside them and be able to walk through doors for them and get opportunities made available to them. And they're in a really unique space right now that they've got time and they've got their attention and they're sober, and the weight of the world isn't on them at this moment. And so we're seeing them at their highest potential. And they're completing things that they never imagined they could complete. So that's a pretty exciting opportunity that we've been able to open up. Also, Fayetteville Adult Education has been coming on site and doing GED prep, and that's been going really well. So we've had guys complete their GEDs while they're with us. And then we have 5 different housing providers that do residential services once a person is in the community, and so all of them are coming on site and meeting individuals and doing interviews and getting to know them. And so we've had 26 individuals utilize those services when they got out. And so that's pretty exciting. Some of them weren't aware of the different opportunities that were made aware through that process. And so that is increasing that social capital that they need to be successful when they get out. So that's kind of the highlights from the first 9 months of the program. Are there any questions?
Oh my goodness. Trying to digest all of that, I've got a smile from ear to ear. I know that we can't do this, but I would love to just hear a testimony from the individuals. This is what this did for me. This is how it did this for me. And now this is a path forward. I have a brighter future because of this. To complete a course in 7 days is amazing.
Yeah.
And then to create an app. But he was stuck in this cycle of breaking the law and sitting in jail. And here we go.
Yep.
And now he's moving forward. That is what this program is all about. Tyson, partnering with you is huge. This is a collaborative effort. It's the whole county. It's not just Nick Robbins and returning home and taking what you've applied there and applying it here. Everybody is lifting up this boat, and everybody is investing in these men, and then soon women.
Absolutely.
I mean, the women's program is not in too far distance, is it?
Yeah, we're working on it.
Are there any questions for Mr. Robbins at this time. I'm just amazed. This is amazing. I have Justice Koger.
Chair, yes, my question deals with the aftercare. You said that there were 5 housing places that you work with. How do you follow up with, they're spread out, these houses, places. So how do the people who stay there get to work? Because I know if they're with you, or when they were in Springdale, you took them to, or you made sure they got to work. So how do we guarantee that these people get to work?
You mean in the other
Yes.
programs? So each program does have their way to employ them. I don't know of any that aren't working on the employment side of things. But yeah, and we have a peer support specialist that follows up with them. So we keep an eye on them. They actually come back. One of the things that they do while they're with us is they go through some training, and one of them is to get to Narcan. And so they actually, when they're released from the county jail, they come back, they get their Narcan, and they get a to-go bag, and we're able to do different things if it's get them phones or things like that. So they stay connected to the peer support specialist to make sure that they are successful once they get out, and the individual are doing really well.
Okay, thank you.
Yep.
Tell us what Narcan is. What Narcan is.
It's to keep individuals from overdosing, primarily on opioids. So it was a grant that we received, the county received. They also have it at drug court, and so take them through the training so they know how to use it. And then, one thing that we encourage them is to help a loved one is the primary focus. So somebody that hasn't achieved the sobriety that they may have, that they can still help them.
That's wonderful. We used to have that, I think in 2015, then Sheriff Helder, they had that on, Narcan was available to them.
Yeah.
That's when they said, law enforcement, you can go on calls and you'll have this, and how useful a tool
Yeah,
it was in saving
absolutely.
people's lives that had overdosed. So I didn't know now it was available to individuals through a grant.
Yep.
Good. Are there any, I have Justice Lopez, one moment, please.
Thank you guys for the work that you do, everyone involved in your program. I'm glad to see so much progress being made by the people involved in the program. My question is pretty quick here. When it's average bond amount, is that in aggregate for everyone, that $48,833.28? Okay, that's an aggregate fee. Okay, that was my only question. Thank you.
Any other questions? Seeing that there's none, thank you so much for your report.
Thank you.
And we appreciate it.
Absolutely.
Next on the agenda, we have the Northwest Arkansas Land and Trust presentation. Good evening, gentlemen. How are you?
Good evening. How are y'all?
Good.
Thank you guys for the invitation tonight. More specifically, Justice Evelyn, I appreciate. My name is Evan Johnson. I serve as the Conservation Easement Manager for the Northwest Arkansas Land Trust. To my left, we have Ben Spade, our Land Protection Director. I will respect your guys' time tonight. This is going to be a very simple who we are, what we do, and how we can help you and your constituents. Ben Spade's going to give the second half of this presentation of the more details of our work. I'll start us off on our first slide here. We'll go to the next, if you don't mind. Oh, I have a clicker. Perfect. So we're a 501c3 nonprofit. We were founded in 2003 by a group of volunteers. We really did not get going until 2009 for our first full-time staff member, and we currently have 7 full-time staff members working to protect land in Northwest Arkansas. We really, we take it, that local and accredited aspect means a lot to us. We work here, we play here, we have a lot of stake in this community, in this area, and Ben's gonna get more into our accreditation and what that really means. Our mission here is to preserve and protect. We're here to preserve and enhance the quality of life for all people in Northwest Arkansas through the permanent protection of land. So where do we work? We service the 4 counties in Northwest Arkansas: Washington, Benton, Carroll, and Madison County. We also serve 13 counties in this area as well, and we are able to operate in Oklahoma and Missouri. We work with private landowners to place conservation easements on their property to ensure that these properties stay intact and are not able to be developed on in the future. Of our conservation easements, we have over 50 conservation easements totaling up to around 9,600 acres within this area, as well as 9 fee simple properties. These are properties that have either been donated to us or that we have purchased for public benefits and public access as well. So back to that mission of what do we do to enhance the quality of life for all people in Northwest Arkansas? When you protect land on the front end, we tend to see cleaner water. We tend to see watershed protection, corridor protection for wildlife, scenic view sheds that are protected, outdoor recreation, as well as local food systems in this area. And to kind of get into the more details of what are the true benefits of conservation in this area, I really want to show this map because it really highlights this slide I was about to talk about. This is the projected growth in Northwest Arkansas along the I-49 corridor from 2011 to 2050. As that corridor continues to expand, we know we will experience a lot more flash flooding events in this area, a lot more flooding events that will not be stopped unless we protect land in Northwest Arkansas. When we have protected green space, there is now hard data that proves that it is critical for flood reduction and flood prevention. As well as when you protect land, people want to be close to green space. People recognize the benefits of being close to publicly accessible areas, as well as they can feel the benefits of that clean air, the clean water for all people in this area. As well as, I'm no tax advisor, I don't want to give any tax advice tonight, but there are tax advantages for these private landowners that wish to place conservation easements on their properties, both for the state riparian tax credit as well as some other tax credits available. I now want to hand it over to our Land Protection Director, Ben Spate, who's going to get into the more details of how do we actually protect this land. Thank you, guys.
Thank you, sir. Good
Hello.
evening.
Good evening. Thank you for having us. We have really 4 main tools: conservation easements. We accept land donations. We'll partner with people to try to protect land. And we also occasionally purchase land. But our main tool is conservation easements, which a lot of people kind of don't know a lot about. But it's a voluntary legal agreement between us and the landowner that permanently protects their land through stopping development, basically. And so it runs with the land in perpetuity, attaches to the deed, just like any other easement in Arkansas law. But the difference here is we meet with the landowners and we come up with all of their future uses for the property, anything they think they could do, their children could do, a future owner could do. And we draft the restrictions on the conservation easement to match what the landowner wants. And those restrictions are typically very flexible. It's all up to the landowner what they want to do. Our main goal is protection of what we call conservation values. And so I'll push back a little bit about protecting water quality and forests and things like that, but really it's up to the landowner, and the landowner has a lot of discretion over how they want to draft the easement. And then as the conservation easement's placed, we monitor the easements once a year to ensure compliance with those restrictions. They last, like we said, in perpetuity. And so the way to think of it is like property law 101. Your property rights are a bundle of sticks, and in those is the ability to, your ownership rights, the ability to sell, the ability to keep people out. What we do is we do not own your land. We take 2 sticks out of the bundle, and that's subdivision rights and development rights. And those development rights that we hold are the ones that we agree upon with the landowner. But this is just to show how customizable it can be. We do a lot of ag easements. We have total forested tracts. It really is we have 54 easements, 52 easements, and every single one of them is different, and everyone's tailored to how that landowner wanted it to be written. And how do we ensure forever? So we're an accredited land trust by the Land Trust Alliance. It's a national accrediting body. We get audited every 5 years over that, and it ensures fiscal responsibility. It ensures we're checking all our due diligence steps, that we're doing what we're supposed to be doing and upholding our public mission. And we're very proud of that, and we just got reaccredited this year. And these are some of our recent conservation wins. We've protected Lincoln Lake, with the city of Lincoln owns that property, and we hold an easement on it, which ensures that it is open for outdoor recreation and public use in perpetuity. We just recently announced that we have worked with a couple partners to protect the headwaters of the White River, which feeds Beaver Lake and all of our drinking water. So that's a huge win for water quality in the region and for the residents of Washington County. We also protected Flint Creek, which is in Benton County, but that's a huge tributary of the Illinois River watershed, which is one of our big focuses. So we're really focused on the Illinois River watershed and that western side of the county. And then, sorry, I can't read that. Oh, we just closed out our Beaver Lake 319 grant, which is through the EPA and through the Arkansas Department of Natural Resources. And through that, we protected 692 acres over 7 properties. So we're very proud of that. It was a huge success. We beat our metrics by almost 200 acres and 3 properties. So yeah, we're very excited about that. We're happy that we're working to protect the water in Northwest Arkansas. And does anybody have any questions that I could answer?
That was a great presentation. Do we have any questions? I have Justice Lemming.
Thank you, sir.
Yeah.
Thank you, Madam Chair. When you say you purchase property, where do you come up with the funds to do that? Who funds you?
It's very project specific, and that's honestly, it's pretty rare that we do that. It would have to be an extreme case, you know, like the perfect property that we're trying to conserve. And then we go out and seek whether we can find federal money, state money, private donors, anyone like that that's willing to contribute. But that's reserved for the most, you know,
Well,
pristine.
I like the sounds of what you said to keep the commercial growth out of that area. What have you heard, or what have you seen, or what have you done anything about the Illinois watershed where we're having this problem with Mr. Drummond over in Oklahoma?
So we haven't, like I said, we are really focused on protecting with voluntary landowners. So people that we either drum up through outreach events or anything like that comes to us and wants to protect their property.
So basically, you're trying to say that if I want to take my 400 acres and tell the government they could never do anything else with it, that's what you would do for me, is you'd make sure that never had anything built on it.
That's our goal. Unfortunately, eminent domain is a very strong power. So if a government entity wants to take it, they can. But as far as private landowners in the future, that's what we do. Whatever you agree in that easement, we uphold. So yeah,
So have you done much work at all in the Illinois watershed?
we've done a couple projects. We're really trying to get more into that watershed, but we have a Lake Francis Preserve, our Flint Creek Preserve, and then we have I'm not sure the exact number of easements, but we have quite a few hundred acres over there as well.
You said you had it preserved. You had that water tested and it tests good?
We haven't specifically tested it ourselves, but yeah.
If you do have it tested, who tests it for you?
We haven't done any testing yet.
So you don't know if you've improved or not?
Well, there's hard science based on how many acres of forested environment that you keep forested and what that effect on water quality is, because it gives a chance for rainwater to dissipate, for all those phosphorus and nitrogen and everything like that to go into the soil and not into the river that goes into the drinking water.
So do you think that the cities put off more pollution versus the farms?
It's a tough question. I guess it would depend. Obviously, with all of the cars, everything that goes on in a city, it's going to have a dramatic impact.
Correct.
Everything has an impact on water quality. It's just about how much, and it's all specific to the area.
Okay, thank you.
Yes, sir.
I have Justice Massengale.
Yeah, thank you for your presentation. Are these tracts of land open to the public typically, or how's it?
So it's all up to the landowner. Most of our conservation easements, there's no public access requirement whatsoever. It's their property to do with what they please. Sometimes maybe people do want to have public access. We've had that. We basically manage our preserves for public access and not necessarily our conservation easements. We don't take any management responsibility of the easement. Really what we do is draft those restrictions and then make sure that those restrictions are upheld. And if the landowner wanted people to come on their property, we can write that in, and that they're more than welcome to do that, but it's not a requirement.
Okay. What do you typically see? Do they typically want to allow public access?
No, most people do not. They want to keep their family, or keep their land in their family, keep farming it, keep doing whatever they're doing. It's very rare, actually, that someone wants public access.
Okay. And I guess once the person, while they're living on it, they'll they'll pay the property taxes, but is there a point where, they're not paying the taxes and you guys have to pick that up, or?
No, so really our interest as defined by the easement is to uphold the easement. So all of the management, ownership, property taxes requirements are still the landowners. Really all we're doing is making sure that those restrictions that we agreed on are upheld. So all of that stuff is still the responsibility of the landowner.
How would that be handled if the taxes weren't paid?
So, it's just like any other property. We've never been through that situation, and we'd have to figure it out as we go
Yeah.
along, but it would be just like anything else. It would, the state could come in and take it, things like that. But yeah.
Okay.
Yes, sir.
Okay, thank you.
Of course.
I have Justice Real Stafford.
Thank you, Chair. Do you all have a minimum size on a property being protected?
So I get that question a lot. We actually do not, but back to that conservation value that I talked about, the smaller the property, the higher the conservation value. So if it's an acre lot with the spring that feeds whichever creek, I would be interested in that. And then the bigger it is, the less things like that it has to have. So it's really just property dependent. I don't have a size requirement. It's just conservation value, which I know is a vague term, but it's, it when you see it kind of situation.
Okay. And then if a member of the public wanted to learn more or contact you to preserve their land, how would they do that?
Yeah, we have our website, nwalandtrust.org. I think I got that right. You can reach us there. It has all our contact information on there, and reach out.
Okay. Thank you all for this great presentation, and thanks for Evan for reaching out.
Thank you all.
I do have a final question, because I do believe that your group was brought up in this Gully Ranch CUP, that you all wanted to purchase his property from him. Is that a truth, or is that just an assumption, a false assumption?
I believe that's an assumption. We never made any, we never made that point or took that stance.
Okay, thank you. Just wanted to clarify that.
Okay.
I appreciate it. It was a great presentation. Oh, J.P. Dennis. I apologize. Mic's on.
You're welcome. Thank you. What does your budget look like?
Just on a day-to-day, or like where do the funds come from?
A
Just
yearly budget?
As far as hard numbers?
Like, yeah, salary,
I don't actually handle the day-to-day budget.
You got someone trying to bail you
Yeah.
out back there.
I appreciate that. That's our executive director, Grady Span.
They say follow the
great.
money, so tell us where the money, tell us about the money.
Hello, I'm Grady Span. I'm the Executive Director of the Land Trust, so it's our honor to be here. It takes about, annually about $600,000 to operate with salaries and, operations of maintaining the land, the preserves and so forth. And that all comes from grassroots efforts of raising money through public donations. We apply for a lot of grants and work with a lot of farm or landowners to accomplish that. So every day is a challenge with fundraising, as you know, with any nonprofit. But we're blessed to be up in Northwest Arkansas where that is a priority.
I'm not sure I know what a nonprofit is anymore. How
Well,
many people?
How many people?
How many employees?
We have 7 full-time employees.
Good salaries.
Excuse
not
me?
all
Good
of-
salaries, 600,000 for 7 employees.
Well, that's 600,000 for the full operation. That's leasing equipment, that's maintaining 2 vehicles, that's paying for the preserves and keeping those accessible to the public. And so salaries is not that full amount, no.
Okay.
And insurance.
And insurance, we do cover insurance for our employees too. So there's a lot of other costs, just like, which is normal with any business.
Okay.
Okay.
Just a hard question I wanted to ask. Thank you.
Well, thank you for being interested. Yes, sir.
Are there any other questions? Oh, Justice Ricker, one moment. Make sure.
I don't really have a question. I was just going to say, I worked with them for quite a few months when I was working for the City of Greenland. We put about 70 acres of our river frontage in a conservation easement through them. Their attorneys drew up the easements, filed everything, never cost the city a nickel, but they did their conservation easement to allow the city to do all the projects they wanted along that river, but not to allow anything else, any development coming in or anything. And they did all of it, it never cost us a nickel.
Thank you. That's wonderful. Good to hear. Any other questions? Thank you. Thank you very much for your presentation. And the website was, again, would you share that?
Yes, it's nwalandtrust.org.
.org. Thank you. Next on the agenda, we have an ordinance denying a conditional use permit recommended for approval by the Planning Board of Adjustments for the Gully Ranch project. I have Justice Lyons.
As we all discussed earlier, seems pretty obvious based on the vote in the last special quorum court, and we just didn't memorialize that by passing an actual denial of that cup. Therefore, I move we pass this on to the full quorum court to do pass recommendation.
I have a motion and a second to pass it on to the full quorum court with a due pass recommendation. Is there any discussion? I have Justice Stafford.
Thank you, Madam Chair. You know, I only have control over my own comments and what I say at quorum court, but I couldn't help but notice that some of my colleagues didn't give a rationale the last time we voted on this, on why you were voting the way you were voting, whether you're for or against. And, you know, this is probably almost certainly going to go to circuit court. And I think we would all have an easier time at circuit court, because if it goes there, we're probably all going to all get deposed and spend time there. And we just went through a big legal battle in federal court. So it may make our lives easier if some of the folks who didn't speak up last time gave their rationales for their votes on this one. And I voted yes on the last one, so I'm voting no on this one. Thanks.
Thank you, Justice Stafford. I have Justice Pond.
Yes, seeing that what we're discussing here is an ordinance for denying this CUP, I would like for the county attorney to advise us what legal reasons we could have for denial that would hold up in a circuit court.
It's not. I better turn my mic off, I might get in trouble.
Let me see. Okay, here are the criteria, and the criteria for allowance of a conditional use. That a written application has been filed with the planning office and the appropriate fee has been paid. That's one. Two, the applicant has provided proof that each property owner as set out in Section 5N has been notified by return receipt mail. Three, that adequate utilities, roads, drainage, and other public services are available and adequate or will be made available and adequate if the use is granted. Four, that the proposed use is compatible with the surrounding area. Five, that the establishment, maintenance, or operation of the conditional use will not be detrimental or to or endanger the public health, safety, morals, comfort, or general welfare. Six, that the conditional use will not be injurious to the use and enjoyment of other property in the surrounding area for the purposes already permitted, nor substantially diminish and impair property values within the surrounding area. And the seventh one is that the establishment of the conditional use will not impede the normal and orderly development and improvement of the surrounding area for uses permitted in the zone.
Thank you.
Thank you, Justice Stafford, for making it clear that we all just have one vote. But that night, it was observed not only by me, by quite a few people out in the county who observed that the only justice on the court that gave reason why they were going to deny it was Justice Coger. Nobody else gave a reason why they were denying it, although there was objections to there being liquor sold or alcohol sold, but he said, I'm not going to have an alcohol license. That I'm not going to do that. That's not what I have. But yet it was still something that was brought up, the reason why they wouldn't support it. Justice says, I don't want to get sued again. I don't think it's right of us to make decisions that compromise the citizens out in the county, and we have to use their taxpayer money that they pay to settle a lawsuit because we just don't agree or like or want that particular person in our neighborhood. And I think we need to be very, very careful on how we vote, because that is where this is going to end up. And we're going to get sued again. When the planning board had approved it, and I asked them, what are your reasons for not? Other reasons were, it's going to be a wedding venue, and they don't want 300 drunk Washington County citizens going to a wedding and driving up and down their county roads. Well, it's not a wedding venue. It was a retreat center. It was an events. And it was small. 3,000 square feet to 3,500 square feet is a small area. I'm just very concerned on how loosely and recklessly we're treating taxpayer money. I have Justice Lopez.
Absolutely. I'd be happy to.
I'm sorry. I believe a point of order was made.
There was a
Mr.
point of order?
President.
I'm sorry. A point of order?
My point of order is that.
One moment, please. One moment, please. Let me get you on the mic.
Parliamentarian. I respect that.
There. I have a point of order by Justice Coger.
My point of order was about the chair was saying that I call this for a vote.
Would you
Are you calling the point of order for a vote or this item for a vote?
Call the ordinance for a vote.
Okay.
That is not a point of order. I have Justice Lopez. One moment, please.
You're fine. I believe that there were several people who voiced their concerns within the parameters of the criteria that we're allowed to list. I think that voicing those concerns is kind of leading to this is the reason that I'm justifying the decision that I had. I know that I made it a point to refer back to the material and what exactly we were allowed to consider. I did do that, and I think that there were other people who did that. I don't think that anyone was taking this decision on a whim. I acknowledge that it is a hard decision whenever we make a decision to take away somebody else's dream. That is a hard thing to do. But it is something that we are trusted on by our constituents to uphold for them, to look out for them, because that's part of our duty, is to look at a dream and say, is this dream compatible with the dreams of the other property owners around there? I had a feeling, and it is, again, it is self-discriminate. I have, in my mind, I do believe that it was not compatible in the sense that it would injure how the people who already live there could enjoy their property. That was my reasoning. And I'm happy to express that to the court and to everyone, because it is, of course, a hard decision. A lot of good people come here with, wanting to pursue their dream, but that doesn't mean that everyone's dream can happen. And I understand that that's hard, and it's a heavy decision to make, but that was my reasoning, and I contend that it continues to be my reasoning.
I do believe, and I
Thank you.
agree with you, that you said number 6, injurious to the other residents that live there, although you made that their enjoyment. I have Justice Wilson. Oh, will you please cue up your mic again, please, Justice Wilson?
Thank you, Chair. I wanted to say a couple of things on this issue. Number one is, I've heard a couple of individuals, I hadn't been trying to keep a tally sheet or anything, but I think a couple of times it's been mentioned a possibility of ending up in a courtroom setting again, or being depositioned or whatever. A person should always be wise and judicious with those things in mind, but on the other hand, I don't think anybody should live in fear of a court case to the point that it interferes with our duties. So there's a balance to that. I think we all understand that. But I also wanted to mention that if we discuss this extensively tonight, and it looks like we're headed down that road, I just would caution us against that, because we at some point we're going to cross a line where we're rehashing the entire thing tonight, and I don't think we need to do that. And especially if someone is fearful that there might be a court case concerning this at some point in the future. You want to rehash, relitigate the entire thing, redebate it all tonight. We do that. We provide ammunition for someone to go to trial with something, or at least to try to. So I just think we shouldn't be flirting with doing something again. I mean, we had a robust discussion before, and it is true that not everybody provided reasons for their vote. I wanted to speak to that as well. I don't think I provided a reason for my vote at the time. But I think, I want to speak to that. I believe all of us, and I think everybody would agree, we have a moral obligation to have reasons why we vote one way or another. I mean, nobody in here, I don't believe anybody on this court or in this committee tonight comes in here and just tosses a coin and says, I'm going to vote one way or another. I think most people are serious and deliberate about what they do and try to be fair-minded. So I don't want to take anything away from that. So we have a moral obligation to do our homework and be prepared and be responsible. I think everybody here does that. But I don't think we have a moral obligation to explain all of the rationale that we have gone through in our own mind to arrive at a decision. It's up to each of us if we want to share that or not. I don't always share everything in my mind about how I arrived at a decision. And that's just me. But, you know, if someone asks me in a legal sense why I did something, I feel confident that I can provide a reason or reasons why I did it. But sometimes I'm not going to explain every pathway I went through in my mind to arrive at a certain conclusion. So for the good of the order, I just submit that. I hope that's helpful. That's just the way I feel about the current discussion. So thank you so much for indulging me.
Justice Lyons.
Thank you, Madam Chair. I find it interesting that all of a sudden we have some colleagues that are trying to compel people to voice their mind. Quite honestly, whether we go to court or not, doesn't matter what we say here. It matters on the outcome of the vote, period. You're going to get sued if somebody wants to sue you, and it doesn't matter from anything else around that. I agree with my colleague. We all need the basis for our vote, because if it does go to court, we will be deposed and we'll have to provide that. And I'll be, you know, we've been counseled to be careful about what we say in public forums, because it may go to court. So it's a line that, it's a gray line we all have to walk, We all have to justify to ourselves why we voted and the way we voted and to justify it, so if it goes to court. So again, I think we just need to move this to the quorum court, and quite honestly, regardless of what happens, it's going to happen based on the results. If we vote to deny it, then yeah, we may get sued by the applicant. We also know if we approve it, just like we are with Molly Wagon, we're being sued by the community. So I honestly don't think what we say here makes a difference on whether we get sued or not. It's what the vote comes out to. Thank you.
I will have to say, and I will defer to the counselor, that you are wrong. You do have to justify why you are voting one way or the other on a CUP, and it's been that way ever since I've been on the court. You've had to say, for this reason, 1, 2, or 4, or 7, or whatever, when you are voting on that, and you have to say that when you give your vote. That's the way it, whether.
I'd like to respond to
I think he has a question. I was just preparing to answer.
Okay.
Now, my response is we've never done that. We don't even compel the planning board to give reason for their vote. I don't if you want to do it, that's fine. Let's put it in the ordinance. Everybody's compelled to answer those 6 criteria on how they vote, planning board members and us. I'm more than willing to do it. We've never done it to date. To my memory, I've never had to do it. None of us has had to do it. The planning board has never had to do it as long as I've been on this court. So again, I don't disagree with it, but if we're going to do it, let's be consistent. Let's put it in the ordinance and compel people to do it. Then there's no question to it.
So my advice has been, and I think I went over this 1 or 2 of these ago and went through that criteria that when you vote, you make it clear on that based on those criteria. The reason for that is there are 7 criteria that are utilized. And so if something's litigated, the first question that's going to be asked is, why did you vote like you did? Which one of these 7 reasons? Tell me based on these 7 reasons how you voted. And so it's better, or sometimes better, for us for you all to be on the record if there's something particular on there. You don't have to, no, but it does help out a lot when we talk about it, because what ultimately we're looking at is whether or not the quorum court acted in a manner that was arbitrary and capricious. And so if you say, well, I just don't like this project, that kind of leans towards arbitrary and capricious. And a court wants to know why it is. There needs to be a rationale, and those are the 7 criteria that are listed. So it's advisable that you know, if there's something on there as a reason for voting either for or against, you know, that's stated. That may cut down on the number of depositions that an attorney takes, you know, which is time taken out of your day. So, yeah, but there's no requirement that you go on the record and say that. It's just advised.
Okay, next I had Justice Massengale.
Yeah, can I call the question?
You sure may.
Okay, I'd like to do that.
We have the question that's been called. All in favor? Do I have a second? I'll second it. I have a second from Justice Lyons. All in favor, raise your hand by saying yes.
Favor of.
Yes.
Calling the question.
Yes.
All in favor, say aye, or raise your hand.
Why are you, Gene?
6. 1, 2, 3, 4, 5, 6, 7, 8, 9. All opposed? 1, 2, 3, 4, 5. That motion carries. And so it's not debatable.
Madam Chair, I would like to comment that I had my mic on
It's not debatable. It's already been closed.
before a lot of these other people did, was not allowed.
Sir, it's been done. It's over. I'm sorry. Do we have any public comment? Seeing that there's no public comment, all in favor of, Do I have a public comment? You need a, please come to the mic and state your name.
Jacob White. I live at 15582 East Black Oak Road. As you guys can imagine, when we saw Gully Ranch back on the agenda, we kind of freaked out because we were like, oh no, we're redoing the vote. And I do want to thank Attorney Lester for explaining the situation. That helped calm everybody down, and we had a less stressful weekend than we would have had otherwise. I do want to say, legally speaking, you guys are not required to state your rationale into the record. The circuit court is going to look at the facts that have been presented to you in the record and decide if your decision was arbitrary and capricious. As a lawyer, I always tell my clients, be quiet. You know, you can justify what you did in a deposition when you're asked. So that's my free legal advice. If you do want more evidence, I would point out that at the January 15th quorum court meeting, at the last minute, the applicant decided to change the entire scope of his project by saying he was moving all of the Airbnbs. So for you guys to assess these applications, you have to know what the project is. Big last minute changes are a good reason to deny. Oh, this isn't Eagle Crest. The county's not going to be liable for money damages for turning down the CUP. There's no protected class services being provided here. So respectfully, you guys are not going to be held into federal court on an ADA claim where you owe money. So the remedy that's going to be asked for by the circuit court is to kick this back down for another vote. It's not going to be money damages. So I don't think you guys have to worry about, you know, the public pocketbook getting picked here if the applicant decides to sue. All right, that's it. Thank you for your time.
Is there any other public comment? Seeing none, all in favor of moving this to the full quorum court, say aye. Aye. And raise your hand, please, so we can get a vote. 1, 2, 3, 4, 5, 6, 7, 8, 9. All opposed? 1, 2, 3, 4, 5, 6. That motion carries. Item number 9 will be added to the quorum court agenda. Moving on to item number 10. We have Mr. Maloney, who will do a update on where we are with the Industrial Development Authority Agency. Good evening, sir. How are you?
Very well. And yourselves?
Doing well, thank you.
This point, just be, I'm sucking on a couple of throat lozenges, just bear with me. So by way of update, it's been a couple months since we were here before you. Latest update is Benton County approved it last week with a couple of amendments added to it that were of concerns to them. And so we're now we've been working with you as well as Madison County jointly. So come before you this evening to ask, one, do we need a refresher because it's been many months? Or two, do we have enough questions that I can answer? It's really however you all want to handle and proceed.
Court, what do you feel? I have Justice Lemming.
We got all night because there's going to be a ton of questions on this deal.
So do you want him to do a refresher update of where we are, or do you want to just dive into the questions?
Well, we probably need a kind of an update to
yeah.
where we're headed and why we're headed and who's pushing this and who's backing it and who's going to pay the money and who.
Sure.
So let's get started. Thank you.
Well, I think it sounds like we just got a lot of questions.
Why don't you update us with what exactly?
Maybe refocus what the purpose of the idea is for? Okay.
If we can do
so
that.
we don't even need the presentation for that. So
No.
The easiest way to put it, if you think about XNA Airport Authority, it's an authority, has a strict mandate to do something. In that case, it was to develop an airport and run a well-functioning airport. The Industrial Development Authority, the Regional Industrial Development Authority, as we're proposing, has a very narrow mandate as well. if you remember when I was here last time, we talked about we have a real estate problem in Northwest Arkansas. We, by and large, if you want a distribution grade building or a cross-dock facility, that we can find in our market all day long. But as the region's economic developer for 4.5 years now, we generally have to pass, or we are eliminated on every advanced manufacturing or technology project because we don't build real estate appropriate for it. Not only that, we don't even develop sites engineered for those types of buildings. So the whole purpose of the Industrial Development Authority, should you grant it along with the 2 other counties, is our mandate would be to find specific sites by which are very compelling, that would be transformative and high impact to build the kind of product that we don't build in this market right now. I'll give you an example. I shared it with, now of course this is a Benton County example, but it's easy to, it also impacted Washington County. So I was asked by a colleague earlier, a couple weeks ago, Ron, when you say we don't build this type of product, what do you actually mean? Can you give me some examples? So I said, well, I'll tell you what I'll do. And I will gladly share it around with this, I'll send it to Justice Ecke and she can share it with you. I don't know why I didn't send it to her already, but I merely said, okay, here's 5 projects that we've lost throughout Northwest Arkansas in the last year. Now, they primarily focused in and around aerospace and defense. And only one of them required a runway, so the rest, it wasn't dependent upon an airport or something, but it's the product that was being built. In all cases, these were very larger facilities, over 300,000 square feet. The prospects that were looking for a product that was already existing, wanted to know if they could conclude a lease within 60 days or 90 days. Wanted to know if the buildings were capable of handling overhead cranes of various tonnage sizes, if the flooring and the scaffolding, the rigging of the building could support those. It is much different than a distribution grade building that we build throughout Northwest Arkansas. So it gives you an example. So, like I said, the whole purpose of the Regional Industrial Development Authority as we propose it is a very strict mandate, just like, say, the Airport Authority does. It's a real estate development. It's to build what the private sector won't. It's not a criticism of the private sector at all. If I was a developer and I knew I could build a certain type of building, it would be leased before the foundation's ever done. It would be a good deal for me. However, as I shared with the Benton County Quorum Court and as well as the Madison County Court, the outside market looks at Northwest Arkansas and says, well, look, we believe you have talent, we believe you have people, we believe there's still a remnant, although it declines year after, every year, of people who know how to make stuff, want to make stuff. And we think we want to cite an operation here from some company that they're representing. But after, like I said, I've been here 4.5 years, and we have not been successful in landing one such project. So that's a lot of prosperity that's passing us by. It's a lot of increasing wages. Wage is enough. I mean, right now, if you look at what our region's average annual wage is right now, but compared to some of these more advanced manufacturing projects, you're looking at an average annual wage of over $100,000 versus below $100,000. It's a lot of prosperity. That's a lot of mobility for people. That's a lot of chance for people who maybe are here and want to go there and they need upskilling or they need further training. So I think one thing is I want to make clear, because this was something that was asked in the other quorum courts. When we say transformational and high impact, does that equal big? And the answer is it does not equal big. What we do and what we have been doing, because the authority doesn't exist yet, but working for the Northwest Arkansas Council, what we do is we look at all opportunities and we say, okay, let's do an economic impact analysis. Let us look at how that plays out 20 years out. And not only does it, how it plays out 20 years out for the community it's in, or the counties in, but how does that play with the other 2 counties that make up our MSA? We are a region, and there's almost nothing that we will do now, and decisions we won't make now or do in the future that will not impact the other counties. I don't know if many of you are aware, probably do, but in 2009, the Federal Office of Management and Budget, OMB, changed our MSA. Our MSA before used to be Washington, Benton, and McDonald County, Missouri. Well, every now and then, they periodically reassess 3 things. How do people move, how do goods move, and how does money flow? In 2019, they determined McDonald County, Missouri was no longer part of that ecosystem the way they evaluated. And now Madison County, to our general east, was. And so that change was made. And so our region now consists of these 3 counties. And each county needs something a little different. But by and large, they need some of the same. So that's all, the whole purpose of the Regional Industrial Development Authority as we propose it is to exist. It's to solve a real estate problem. And that real estate problem leads to other greater things. I shared with you last time I was in front of the court. I've been doing this for 26 years, multiple states and internationally. And I'm going to overgeneralize the dynamics of location consulting and how locations, either from a company that's already in our region that wants to grow or someone from without the region. It's very simple. I'm going to oversimplify it, but this is the way I see it after 26 years. If you don't have the right sites, you're not going to have the right buildings. Real estate gets you in the hunt. It gets you in the game, whatever term you want to use. As you continue through that very exhaustive selection process, and at some point your people are going to win it for you. We're going to move. If we prove that we've got the right sites and the right real estate, we advance on to that search. And as we get from the top 10 and into the top 10, we get down to the top 5. It's very competitive. Your people will win the day for you, okay? And then when you get down to the last 2, it's going to be your quality of life that seals the deal. But it all starts with real estate. And so, not to overemphasize or be repetitive, but that's the whole purpose of the Regional Industrial Development Authority is we're bringing it forward to all the 3 counties. It's to solve a need with a very strict mandate, and everything else beyond that is either an outcome or an outgrowth of it. And I would love to take any questions that you have. And I'm sure there's many, because I've been put through 5 months of the ringer with Benton County, so please, I know there's questions.
I do have a question, and I shared this with you earlier. There are guardrails, sideboards that we can put up, because Washington County at present has a zoning ordinance that has to be abided by. And I mentioned that we had a lot of feedback from our county citizens that they do not want wind farms in Washington County, nor do they want manufacturers manufacturing those turbines in our county. If that was one of the sidebars, guardrails, to say, we don't want this, now is the time to put that language in, correct?
It would be, but here's the thing, and this was a great question that was asked over in Madison County, who is struggling with planning and zoning in the county right now. There was a point that was asked by several members of the Quorum Court over there. I said, hey, Ron, if we do move ahead with planning and zoning, is the authority, if it's created, going to abide by it? And it's a very simple answer. I gave it to them. Wherever zoning and planning exists, anywhere in the state of Arkansas, a company, a board, an authority is required to abide by it. Creating an authority like an industrial development authority does not supersede, circumvent, or anything like that. So whatever guardrails you all put in place are the rules by which we play.
And now can you address eminent domain?
Sure. So if you recall my very first presentation I gave, there was a particular slide, it was a map of the United States. And Arkansas sitting in the middle was yellow with 5 or 7 dots, green dots. And then it showed all the surrounding states. And the darker the green, the more pervasive the use of industrial development and technology authorities. But when you looked at Arkansas, it's just those dots. And everyone, I remember when we were first here, and I know this was months ago, but you may remember everyone goes, oh, that's where the ports are, along the navigable rivers. So when Industrial Development Authority legislation was first introduced and became popular, it was in the 1960s. And almost all the states did the same thing. It started at the ports, or navigable river, inland ports, inland rivers. But then as time went on, they became more pervasively used. First they went to cities, then they went to counties, then they became regional in the nature in which they operated. Arkansas never changed. Until we had Act 576 was put into law in the last legislative session, Arkansas was still operating in a 1960s paradigm when the rest of the nation moved on. Put yourself in my place as an economic developer. You say, hey, Ron, we need you to go out and do this. Let's say we create the authority. And you say, Ron, on behalf of the region, we need you to go out and do this. And I go, great. All right, the best tool for that is X. And I reach into my toolbox, and whatever your favorite tool is in your toolbox, imagine it's not there. What it's like for an economic developer when you don't even have the benefits that go along when you create an authority like this. So, eminent domain was in the original legislation from 1961. I might be off 1 year on that. When we expanded the original legislation, the ports asked us not to change their enabling legislation. So what we did is we took their enabling legislation and we simply added to it. So what I mean by added to it was, in the old legislation, it said you had to be on a port and navigable river. So that left almost all of Arkansas out of the game, out of the opportunity. So we changed it, we expanded it. So it could be any city could have it, any county could have it, any 2 counties could have it, any 2 counties could cooperate. One city over here and a county there could cooperate. And we just expanded it so there'd be the maximum amount of opportunity. Something you always hear me say, there's always multiple ways to get to X. Now, when we expanded it, we had the balance, or we tried to balance liberty and agency and, what's the word I'm looking for? And just ease of use. So if you determine as a community, anybody in the state of Arkansas determines as a community, we decide we want to do this. Maybe 5 cities in one county want to do it. That's their right, that's their freedom. We think at this point in time, the way our region operates, the best way to do it is a region. Now, when we upgrade, like I said, so that's what when I say we expanded the legislation, that's what we're talking about. Never thought to take eminent domain out. Just, it had been there since 1960, never even thought to take it out. Now, one of the things that the Benton County Quorum Court has asked us to do, and I committed this in public, is that when we go back into the next legislative session, we will reopen that legislation and we will take it out. Personally, so you know, I am not a believer in eminent domain. Okay, never have. I've been doing this for 26 years. I've done over, I don't know, I stopped counting at 3,000. Done 3,000 projects in my career, and not once was there ever an occasion where eminent domain or condemnation was a way to solve something. If you want to lose friends and lose the faith and trust of a community, use eminent domain. Like I said, I'm not a believer in it, and it would not, if I am running the IDA, it would not be the way we do business. But I know words are cheap, so as we said in the Benton County Court, we've already talked to Senator Dees and Representative Tories, and they have also publicly said in public that they will lead the charge, along with others that we will get as far as a delegation, and we will reopen Act 576 and remove There's a couple things we want to tweak as far as board appointments and the way to recall people, should you get a bad actor on a board, on the IDA board, but also to remove eminent domain. Because
Okay.
we just, it's just, it is, I want to say this, it is not, by no means, and what am I going to say is, am I diminishing it? It is a very important issue. And, however, again, from my perspective, 3,000 opportunities, I've never seen an opportunity where I'd even think that that was the right way to do. You know, the responsible way is to work with the landowner. And that's what we do. And that's what I've done in a few other cases where I've had, you know what, was I willing to pay more money? Was I able to find an ulterior solution? Absolutely. And that's the way we would proceed here.
We have some questions. I have Justice Massengale.
Yeah, thank you, Ron.
Hey, how are you?
Good, you?
Very well.
So, one question I keep trying to understand is, I mean, I think what you've got planned out is a really good thing, and we need some strategic planning and getting industrial development. The only question I've got, or the biggest question I've got, is why do you need an IDA? Why can't you just go do this without that as an entity? Because you're going to raise money selling bonds, and then you're going to develop these projects. Why can't that be done without having this as an IDA?
So when you form an IDA, you have ability to bond and other tools, okay? If someone does not give us a permission, an IDA, so I think just so everybody, Justice Massengale understands that when you create an IDA, it becomes a public body. So it becomes separate, a living entity within the state of Arkansas, okay? So just so we're clear on that. When you create that, when let's say all 3 counties, like Benton does, and the other 2 counties approve it, this thing now becomes a living entity, and it has those abilities. Now, you could, as a city or a county, you could do your own. That's perfectly your right. And, but again, then let me ask you, how many cities and towns are in Washington County, roughly?
13.
13, okay. So now all of a sudden 13 towns decide they're gonna all do the same thing. They're gonna be repetitive. They're gonna create staffs, salaries, operating budgets. And they're all gonna do that. Now that's a huge expansion of government. Whereas if you wanna look from an efficiency standpoint, you could do it at a regional level, 1 staff serving 3 counties or 2 counties, whatever it is the counties end up doing. It is, again, your decision how to balance this. You know, when we expanded Act 5 and what became 576, we said we need to allow local communities the freedom to do as they want, but we also want to offer efficiency. And the other reason is the business has changed since I came into it in the 1990s. At that time, there wasn't the data sets and the internet, and email was brand new, and no one even trusted it. You could communicate by it, but you wouldn't dare trust an attachment to it. But now, and so location consultants, companies, they had to reach out to you, because if they wanted answers to questions, they had to reach out to the economic developer. Okay, well, so if you were a city, if someone was interested in, they reached out to you. But today, starting about 2009, is a complete change, because the internet, large data sets, and now AI, which allows you to comb through data even easier, now most communities don't even know they were ever considered. So they now, instead of starting at a local facility or a local community and asking questions and getting, getting proof if they need it of like an ordinance or zoning or whatever it is, now you're often considered and you're off the list and you never knew it. Because what they do now is they start at a state, they go to regions, and the regions are really the gateways now, not a gateway as a keeper, but as a gateway of entrance to get information. And so when what we propose, and one of the reasons for doing this as a 3-county regional IDA, is simply, if this is where the opportunity is coming through that doorway, then who's better to handle that? And we, quite frankly, we have the interest of every county. I mean, it's not like there's no competition here. I'm going to share something with you. Justice Bollinger asked us in the last session at the quorum court meeting, and he didn't know this, and I never even thought to tell him to, but I don't know if you all know that when projects and opportunities come in to the region, and they come through the Northwest Arkansas Council, for every city that has a chamber, we have a protocol set out, and it's been this way for over a decade. And that is, no matter what the project is, whatever the opportunity is, we send it out to everybody. Doesn't matter, it's not like Ron sits back in the office and goes, well, I think this is a good thing for them, not a good one for them, and this one's a better fit. Everybody gets equal shot at it. And so at the IDA, we're doing the same thing, we're just elevating that. So like the council, we handle things coming in, but what we want to do at the IDA is make sure that every community has the best opportunity to grow and get a best shot at it. And that's what I could say.
Great, I have,
Well, I'm not,
Oh,
still got-
go ahead.
Can I ask more questions?
certainly.
Okay. So what document defines this IDA? Is there a document that
I
says
sent-
what this entity is? Huh?
Yes, I sent in an email
Oh, okay.
all of those documents.
Okay, sorry, I guess I didn't get that yet. Okay, I mean, I probably have it in my inbox.
So just since everyone, it sounds like some people, yes, remember, this is what it was the first time we came to court. Some people had it, some didn't. So here's what it is. Act 576 is the enabling legislation. Then
Signed by the governor.
Signed by the governor as part of her, if you remember, there's 23 things she passed in her economic development package. The next thing is that I've sent over time is a draft of what the ordinance would look like, a draft of what the proposed bylaws would look like, as well as an operating agreement. So when the IDA gets formed, the Judge Deacons is gonna bring candidates for board members to you. You guys are gonna vet those and approve those, and then he will make those appointments. And that will happen by all 3 counties. So when the 3 counties come together, there's going to be an operating agreement, and there's a draft of that as well that says, okay, well, now that we're all together, this is our board size, these are how we're going to make decisions, and so on and so forth. And so that's that kind of body of documentation that some have seen. I think last time, half of you, it was in your junk folder, like, for whatever reason, an email comes from me, it just goes into junk. But some of you had it, and maybe that's what's going on here again this time. This time I did send in to Justice Ecke, so that hopefully that wouldn't be the case again, so.
Yeah, still got some questions.
Okay,
So this creates another government entity. What powers does this entity have?
Has the power to buy, own, sell, develop, lease real estate in a nutshell.
Okay.
And we have the power to bond using industrial revenue bonds versus general obligation bonds of the community. In other words, when you do an industrial revenue bond, the company that is getting you're doing the bonds on their behalf, they're repaying the bond. It is not the citizens or the community. So.
Does the IDA have the authority to grant special tax benefits?
Under certain circumstances. So let's make a distinction. There's an abatement, and then there's what's called payment in lieu of taxes. So an abatement is you're abating it, as the word says. Payment in lieu of taxes, what you're doing is you're structuring tax payments.
And would that come to the quorum court for approval, or would that just be approved by the IDA without?
It would be depending upon ownership of the land. So if the IDA owns land, we would be able to do a payment in lieu of taxes. If we develop some land and we sell it, and the company it's not owned by the IDA, and the company has purchased it, it then goes on the tax rolls, then that comes before you, or whatever your county process is. If that makes any sense. If it doesn't, I'll be glad to talk more about it.
It does say on the financial exposure, revenue protections, and infrastructure risk. Question number 10 was, how does the IDA protect the county's revenue base? The IDA has no taxing authority and cannot commit county funds.
That's correct. So we're not asking for money. We're not going to come to the county and ask. So the easiest way I can put it is, when we do a development site, let's just say it's a square. We draw a square here. We're responsible for doing everything right within that square. Yeah, but that doesn't mean we come to the county and we say, oh, hey, we need you to pay for these interior roads, or we need a water line extended, or whatever. That is our job, using the bonding ability and the proceeds that come from it to take care of that. So that's how we're protecting county resources.
But it sounds like you do have, on land that you own, you retain the authority to implement an abatement or a payment in lieu of tax?
Okay, so what we have in Act 576 is not the ability to abate, only the ability to do payment in lieu of taxes.
Is that just for the property or the improvements on the property?
Well, so it depends so not all real estate is equal at a moment in time, but let's just take a very simple example. Let's say, we find somewhere here in Washington County, we find a piece of property that, for whatever reason, can be with some improvements, becomes quite more valuable. So maybe right now, that land, whatever it is, whatever size it is, I don't know, pays, $4,000 a year in taxes or whatever. So we make those improvements, and that land becomes much more valuable, and a company comes along and says, yeah, we're going to invest a couple $100 million. Okay? Well, they're putting a lot of money up front. This is the difference between abatement and a payment in lieu of taxes. Payment in lieu of taxes says we're going to negotiate so that the community does get some tax, versus abatement is an abatement. So the company says, well, we're going to put a lot of money in. So can we structure a tax payment so that we're paying less in the beginning, but more on the back end? And in the Arkansas's law, you can't be less than 35% and greater than 60. So just do the math. If the property was originally only producing $3,000 of real estate income tax for the community, and we do our job right and we maximize that property, and now it's going to be assessed at a much higher value with a potential tax payment. Well, sometimes payment in lieu of taxes is how you get a company to say, okay, I will commit all that money up front. So then when that payment in lieu of tax agreement is over, then it enters the roll of the tax rolls at the assessed value at the time. And payment in lieu of taxes is also, there is no set formula. And it's not like it's not like a granted, like, oh, it's always 30 years or it's always 10 or it's whatever. It's literally a negotiation. But it is what is best for the community. And I think this is a little something that I would want to interject here. So even though the authority is a living thing and it becomes a living thing within the state of Arkansas, this is a question that was asked a lot over in Madison County. There was this automatic assumption that somehow once it gets created, we just go off and do what we're going to do. Well, no one just operates in a vacuum, okay? We're going to be part of communities, part of the county, and if you think that we're not going to be seeking input and public comment and all of this, it's just not the way we do good business. I mean, no one else could operate that way. Why would you think we would? I mean, IDAs are not some big bad thing. We are a collaborative instrument that is going to help any region, any county in this region, any community where we can. It's the whole reason we exist, Because the private sector isn't doing it. We're trying to help the communities and help the counties. And you can only truly, you know this, in any facet of life, you can only help somebody if you're collaborative, you're empathetic, you're communicative. That's just the way, it's the way you translate it in the business, as you would do in life in general.
Okay, I have Justice Lopez.
Chair, may I ask, since I have comments to make, I don't have questions at the moment that I go after. I'd like to let the people get their questions first.
Certainly. Just cue your mic when you're ready.
Thank you.
I have Justice Stafford.
Thank you, Chair. And bear with me because I think I have like 5 deep dive questions here. So, you know, I read the news article about Benton County passing their version of this. They passed like 3 to 4 amendments added onto it that are not in the version that we have in front of us. They had to do with a couple you mentioned already, eminent domain, recalling members.
Yes.
A severability clause, basically saying if any part of it was determined to be invalid, it wouldn't invalidate the whole thing. And it sounds like maybe they passed one that had to do with appointing a member of their quorum court to the authority board. I'm not sure if that passed or not. But regardless,
It's already in there.
it is in there. Okay, so the version that we have in front of us, at least this ordinance, doesn't have any of those specific things in it. Is that in the, are those things in this bigger document or what?
Okay, so
And I have a follow-up question to that too.
Okay. So there are 2 amendments in the severability clause. So when I sent those to Justice Ecke, we didn't have the signed document from Benton County.
Right.
So what I did send her was the 2 amendments and the severability clause. Now, this afternoon, I got it from the Benton court, the signed, dated version, which I could then just send on tomorrow. So, but it would be this, you'd have what it looks like. But I did send the 2 amendments in the severability clause.
Okay, so, and this may be a question for Mr. Lester too. What if, and because Madison County hasn't even voted on theirs yet, what if different counties vote on different amendments that contradict each other or in opposition to each other?
Well, then the 3, if in general it passes, it's because there's a general desire to do it.
Yeah.
So if we get 3 ordinances that look slightly different, well, then there's gonna have to be a process of harmonizing, so to speak.
Yeah.
And that just means we come back and we do more work together.
Okay, so,
Okay.
so does that mean that we need to put the same amendments into our ordinance that Benton County has in theirs to harmonize? Or how does that work?
To be truthful, I don't know. We are the first ones in
Okay.
Arkansas to
Yeah.
do this. So we are leading.
Yeah.
Sometimes leading means we are
Okay.
taking some unknown steps. But at the end of the day, what we need to do is
Yeah.
come up with an ordinance that is uniform for the 3.
Right.
Okay, so.
And that's
it's
what I'm
very-
asking, because right now ours doesn't match theirs.
Right, but if I had sent what I got at 3 o'clock
Yeah.
to Justice Ecke, then you would have at least what Benton's looks like. So just so you know, the First Amendment, one of the amendments dealing with eminent domain, that they lifted right out of the Madison County ordinance. So that's like, there's some agreement already between Madison and Benton. Because they sat there in the court and Tom, the county attorney, just pulled up Madison's, because they were debating this, and they said, well, wait a second, why don't we just look and see if the language that's already in the Madison County ordinance, if that works for you guys. So he read it out loud, and everyone goes, yeah. So they just literally took it from Madison's and plopped it in the Benton. What I would say is, let's just work through the process, okay? And when we come at the end of the day, this ordinance on what you all decide is maybe slightly different than what was in the Benton, and maybe what will be slightly different in Madison. But at the end of the day, if we really believe in what we're doing, all we just do is a little more good work till we're all satisfied with a product that we could live with.
Okay.
Yeah.
So that kind of leads me to my second question, which has to do with this disaster supplemental grant.
Yes,
There's a deadline coming up on that.
There's a deadline.
March 3rd. And it sounds like Madison County isn't even going to vote until February 17th. And then assuming that after that, we may all have to come back and
Right.
vote again to coordinate. It doesn't sound like we're going to make that
no, we are going to
deadline.
make that. So here's the clarity. So one of the justices on the Benton County Court says, how come we're only hearing about this now? If you read the article, it was at the committee of the whole meeting, I said, look, we came to you 5 months ago. Never thought it'd take us 5 months to get here. At the time, it wasn't urgent because it was 5 months earlier. And, you know, a lot of this is my personality, okay? I personally don't think it's ever fair to start any conversation with anybody by dangling a carrot. So even if it was 6 months, 5 months, or 3 months ago, I would never have come to any of you and said, oh, there's this grant out here, and we need to hurry up and do this. That smacks of being disingenuous, and I am not that kind of person. But to go back to what I said, I never thought it would take Benton County 5 months to get where they're at. But what we've decided is if we could have done and got the IDA together, that would have been like putting your A-plus team to win the grant. However, the Northwest Arkansas Council is still an economic development organization. It qualifies by the rules. It's like putting your A-minus. So I can live with that. And so we are going to make the application. We are working on the grant application right now. There is something in it for in every county. I'm telling you that right now. So there's not one county that does not have some kind of project that's in this. So the EDA, so everyone understands. The EDA grant is not to replace things that were lost during the tornadoes 2024. All that EDA grant says is if you were impacted as a region and you suffered, well, then what we're going to do is we're making X amount of money available to do things that make your economy more resilient in the future, more transformative, and that's what we're doing. So there's a transformative aspect to the EDA grant, which is up to $50 million. Then there's project implementation and planning. And so there are planning elements of it, implementation portions to it, and then the overall transformational piece. And like right now, there is no county that will not be represented in that grant.
So even though, follow-up question to that, even though the Northwest Arkansas Council is applying for the grant, then would they only be able to administer that, or could that be used for an eventual IDA if it passes?
So what we're going to do is we are hoping that by time March 3rd happens at 5 p.m., we at least have an approved ordinance from all 3 counties, okay? And the EDA only requires us to show that we are moving forward in that place, because one of the things you can do with the EDA grant is, let's say you are applying for another grant, which we are, that gives us some initial operating costs for a staff of 2. You can then, if you can show that you're on your way to creating that thing, and so let's say we don't have it all done, but we have ordinance has been approved, okay? Then what we can do is, there's a part of that called the planning and implementation, where certain costs within the budget of the grant that we're applying for to get us off the ground can then be maximized and considered as a match, and then they'll match towards it. So that gives, if you want to look at it this way, the IDA a little more runway. Initial grant that we're applying for already, the EDA matches that. But what we're really looking at is implementation projects. Because remember I said, the IDA exists to develop real estate that is going to lead us to a better and prosperous future. So there are some communities in all 3 counties who they just simply need help with planning. Like, we've got a site or we've got this asset and we need to be able to do more, but we don't know how to do that yet. So for those instances, we're going to put in the community, in the grant, for that kind of money to help with that. But then there are actual real estate development projects that we want to do. And the one thing that is beautiful about this EDA grant is that it allows for infrastructure improvements. So you need to move dirt, you need to grade a site, you need to add a water line, you need to move water lines, you need to put a pump station, you name it. Unlike a lot of the EDA grants in the last number of years, which were a little more theoretical and pie in the sky, what I love as an economic development, this one allows you to apply it to infrastructure. And so there are many infrastructure projects and development projects that we will. And that leads towards the overarching transformational aspect. So.
Okay, so I think you may be partially answering my third question that I'm coming to.
Well, fire at me.
Which is the chicken and an egg question,
Yes.
right? So I'm familiar with how, industrial parks work, public-private kind of things. You know, the classic example, if anybody, watch a documentary about the history of Silicon Valley and how Silicon Valley became Silicon Valley back in the 1940s. And a lot of it started with the Stanford Industrial Park, which was jointly run by Stanford University and the city of Palo Alto. And through that public-private partnership, you created this gigantic, global economic engine. But the seed of that, right? So you have an industrial park, and you improve a piece of land to make it shovel-ready, so that you can attract a high-tech company to either purchase or lease that piece of land, and then the revenue from that gets used, I assume, to work on the next piece of land, and so on, right?
Correct.
But how do you start? How do you get that first piece of land purchased and made shovel-ready in order to attract somebody if you haven't attracted somebody yet?
Well, there's many ways. I'll tell you the example I did in Mississippi. So set the stage so everyone understands. I worked for the Golden Triangle Development Link, which was 2 counties, Oktibbeha, which is where Mississippi State is, and then Columbus, City of Columbus in Lowndes County. Clay County right to the north. Very rural, very poor county. Not very large at all. And they were basically a 2-horse town. And both businesses left. Well, there's 3-horse town and 1 remained, but the other 2 left. And the year before I took the job there, unemployment was over 27%. And when I got there, it was down to 17, but still 17% that's a lot of unemployment. So my boss, who I worked for, we had looked at sites, and the community, to your point, had, before they asked the Columbus Lowndes Development Link to undertake this project on their behalf, they had picked a site that they thought was a great industrial site, and they didn't have a site visit in 10 years. And the community was completely demoralized, whereas the development link, 1 county south, was just kicking butt and taking names. $6.5 billion in new investment, 4,000 new jobs. And the Clay County says, well, what about us? So they decided that they would join the link, and their one request was that we get an economic developer dedicated to us. That was me. But it goes to your point, Justice. There has to be a certain amount of vision, and there has to be a certain amount of courage to act. And so what we did, to your point, in this particular one, we optioned the land. So we didn't have the money to buy the land, but we optioned the land. And then we went out and proceeded to go find the client, the right client. And then before we did that, though, and this is part of the way I operate, if we stand up the IDA, and I am the executive director of it, every project that we will do, the community gets a chance to have input to it. So what we did, I'm sure the fire marshal's not going to appreciate me saying this, but the community center held 800 people, and we had 1,100. but we invited 10% of the community in. And we said, look, this is what we think the best opportunity is. And if you agree, then this is who we're gonna go after. And the community was fine. And they said, well, what does this sound like? What does this smell like? What's jobs like? And we shared it all, and we just laid it out for them. And they said, okay, we trust you, go forth and do. So then we ended up, when we brought them, not everybody wants a tire plant, but I guess when you have 17% unemployment, a tire plant looks pretty good. But that's what they wanted, and we delivered it. So we had option to land, and then when we did the agreement in the deal, part of it was done through so in most places like in Georgia and Mississippi, almost every county has a small industrial development authority with the same powers that we're talking about with this one, that runs in the background for the forward-facing ED, Economic Development Unit. And so with that, and with money from the state of Mississippi, we took the option and executed it, and we bought the property, and then it was sold to them, and now Yokohama has, well, it's on phase 2 now, and I haven't visited in 10 years, but it's got like thousands of people working there. So the point is, there's lots of ways we can do it. You can option land if you start. If you look at the legislation, somebody can even donate land if they want.
Okay.
There are so many ways. Like I said, you will hear me, as your regional economic developer, you will hear me say this all the time. There's a dozen ways to get to the X. You just have to figure out which one's the right way.
Okay, I'm glad I asked. So there's a lot of different, I thought you were going to say the disaster grant or something like it.
Well, the disaster grant won't let me buy property, but what
okay.
it will do is allow us, if we have different projects, allows me to figure out. So it's not just buying the property, it's the improvements to the property. So what this grant does is allows us to apply money for improvements. Infrastructure is costly. We know this. You're Quorum Court. You're just like Benton and everybody else. You are struggling with infrastructure all the time, right? There's always questions. Where do we get the money for water? Where do we get the roads for sewer, roads, everything? These are the questions that face you probably all the time. So as the IDA, this comes back to this collaborative nature of a partnership, is when someone asked us on the Benton County Court, well, Ron, how would the IDA impact infrastructure? And the way we do it is, I say, if this is, I'm not being, this is the site, I'm responsible for everything in it. Engineering it right, studying it right, getting it right, so that I'm minimizing the impact and also going out and getting the money for it, so that we're not coming back to the community and saying, oh, hey, we misjudged, can you help us put a road, or can we this? That's not what you have a professional staff at an IDA like this for.
Okay, last question for now, I promise. This is an agreement among counties, right?
Mm-hmm.
The sites in the enabling agreement, can the sites be anywhere? Can they only be in unincorporated land in the county? Can they be within city limits?
So remember, the idea behind this is it's to be impactful and transformative, which again, I always stress, does not equal big. It is, if we do this and we measure that out 20 years, does it really have not just an impact on that community, whether it's unincorporated land or within a city, does it really have that kind of maximum benefit? And if it does, then the next question we ask ourselves is, how does it benefit everybody around them? That's our guiding principles to this.
Thank you.
You're welcome.
Okay, I just saw, there you are. Kyle Lyons, thank you.
Thank you, Madam Chair. Well, the good news is you answered some of my questions. Thank you, JP Stafford. Talking about, a lot of it was, you took us through the shovel ready, that helps. You talked about just the dive a little bit more into the funding. You get your funding through grants, bonds that you sell, et cetera. And then when a company comes in, they buy it from you, and then of course you have to pay back those bonds, et cetera, and then anything other than that then gets reinvested.
So there's three ways. There's generally three ways when we get land and we're using it, there's three ways we can do it. Some companies will just want to execute a land lease. Others will say we want the IDA to do a build-to-suit and lease back to us. And others will say we want an outright sale of the land.
Okay.
So each way, one of those makes it. Now, a well-run IDA becomes self-funding at a certain point. This is why we've never come to any of the three counties and said, we're asking you to put money in. Because we know that if we do these right, as we, not only just from the bonds, but from the rental agreements and everything else, in time, we are going to be self-funded.
Yep.
And that's the whole reason to do this, is to take the burden off the communities.
We're talking about planning ordinances, and all the planning ordinances of the county takes precedence. But when does that get initiated? So, for example, I can give you my assumption, but for example, in Washington County, everything is residential and ag. If you want to do anything else anywhere in the county, you have to go through the CUP process, which we discussed earlier. So that process gets started after the company decides they want to come here, they like your site, they want to buy your site, and then they go through the CUP process. That way the company and the type of industry that's going to go in there will be known? Or is it done when you're doing the shovel readiness, per se, of it?
So it starts during the shovel readiness. So, like I said, a company is going to trigger the actual going through the planning and zoning, okay? However, when we're doing a development site, if we know that a community, just for a moment, set aside planning and zoning specifically. However, if we're going to develop a site and maybe it's, I don't know, it's an unincorporated, but right across the street is the boundary of a town, one of the towns. Okay. We would be negligent, if not negligent, stupid, not to go talk to the community. Is it what you want? I would go have a preliminary conversation coming back to planning and zoning, and come back and have a preliminary conversation with planning and zoning. Because no one wants to be surprised at the end. Okay, no one wants to feel like, oh, our back is against the wall, time is against us. That's just not professionally how we operate. So, during the development phase, if we believe that certain types of companies are going to be the ones that would want to take advantage of this development, then we're going to go fill the community out, and then we're going to fill the county out. And then we're going to start having some preliminary discussions with planning and zoning to make sure it would be acceptable. If it's, when the example I gave you, Mississippi, they had some little bit of zoning, but no planning in the county. But still, that's the reason we pulled 1,100 people in, 10% of the county's population, is so that we could have a sounding board kind of experience with the community. Because why would you go down a road to find out when you get down to the end of the road, nobody wants it?
And that's kind of where I'm going, because, well, first of all, if you're going to put infrastructure in, you have to follow our planning. I mean, we specify roads and all that stuff, right? And you abide by that. But you go through it when you're doing that infrastructure, it's going to be difficult because the citizens, maybe what you're saying is you're going to come and say, here are the types of companies we're going to attract. We just don't know which one's going to actually take it. And I guess given going through the CUP process throughout my career on this body, I'm not sure that it's going to go over with the citizens. They're going to want to know what type of industry you're going to bring in, who's it going to be, and then you're going to get the reaction based on that. And where that's at in that process is going to matter, I think. Does that make sense?
I think I followed you.
Okay.
Let me just tell you what I think I heard, and
Okay.
you tell me if I'm right. You're saying the communities, the county would like a little more upfront about like what kind of industries we're going to go after. That's fair, and that's something we would do. It's not. There's no hidden agendas here. We know already. I can tell you right now. There is so much interest coming to Northwest Arkansas from all things aerospace and defense. Now, does that mean everything is about building aircraft? No, but there's a lot of innovation and research being done at the university, and there's components and systems to these things. And it's part of what we're seeing. And this is part, a little bit, I think, where the nature might go with Washington County, because you have the research university, whereas the other counties don't. So this is what I'm saying. It's not going to be a cookie cutter for every county. Each county, I had this very explicit discussion with the folks in Madison. Every county in this region has something that's special and unique about it. It's not to say the other counties don't have it, but there's something really, really compelling about each county. And Madison was like, well, what's compelling about us? Well, one, we're going to this aerospace and defense. I said, well, one, you have a county airport that has no flight restrictions on it because of where it sits. It's outside of all military operation areas. You know, if we had a couple small drone manufacturers, mobility, you know, I don't want to say like flying cars, but you know what I mean, like eVTOL type vehicles that get, you know, like flying taxis and things like that. That would be a perfect place to do it. And can you imagine one or two companies in Madison County, kind of that kind of technology? We're talking like a 50,000 square foot building in each case with 50 to 60 employees being well paid. That's transformational and impactful for them. But it would be different for Washington County. And because you've got an R1 university here, it might be a little different than what it looks like in Benton County. So the point is I can tell you generally already what a lot of companies are looking at all of Northwest Arkansas for, in very broad brush strokes. It's technology. It can be in multiple industries, not just industry and defense, or aerospace and defense, but technology and technology that needs to be made and assembled. This is where we've gotten a ton of interest in Northwest Arkansas. So it's a matter of finding the right sites, the right places that fit with the community's makeup and what the community wants. And then it's just all about thoughtful conversation. This isn't, I don't know. I know in other places where I've worked, it's kind of like the heavy hand of government and economic development, and the communities feel like things are being pushed down on them. This is not the way. First of all, we all know this is not the way we do things in Northwest Arkansas. It's not the way the Industrial Authority would do it either.
Appreciate it. I just believe, based on my time here going through the cups, if we try to zone it through a cup, not knowing what the industry is, we're going to get a lot of citizens against it because they don't know what the industry is. It's just these types of industries. But if we wait until we know what the industry is, we haven't solved the problem. Really.
Well, like I said, we're going to start that process early. And plus, we already have, like, as Justice Ecke said, you know, like, look, if you've got the guardrails in place, or even, the guardrail can be more than just what's absolutely written in your planning and zoning. This is why you go out and you do community listening sessions. Yeah, because if you know what communities want and they don't want, that's an unofficial way of finding this out before you actually even get to planning and zoning. Like, it's just a responsible way to do economic development. That way, when you do get the planning and zoning, you're able to say, the companies will trigger it, but you're right. You're going to want an advance notice. So what I'm saying is, I may not always be able to tell you yet what the company is, because maybe the company hasn't come. But I can certainly tell you the direction and the avenue we're going. And so you have that sense already. And then you're going, okay, well, Ron, tell me what that universe of companies might look like. And I will do that. And it could be multiple industries. And I'll say, you know, this is kind of how I've made my name in my industry for 26 years, is I'm really super good at looking at industries. And I can tell you who's made their move and who's going to make their move. And it really becomes not too hard, a rocket scientist, to figure out who you might be getting. It's just, if you're willing to spend a little money on data tools and you're an inquisitive mind, you can figure this out. It's not really that hard.
Okay, earlier you talked about a scenario, and I don't know that I wrote it down right, to where what I think I heard was the IDA provides permission for a company to do a purchase in lieu of taxes. Did I understand that correctly?
That can be true, yes.
So-
Depends on ownership of the,
So
who
just-
owns the land.
Just for my confusion, in your FAQs that was provided, I think the first set, number 11, how does payment in lieu of taxes agreements work? A pilot purchase and property tax payments to ease company costs while guaranteeing revenue to local government. Pilots require approval by the county or city involved and are project specific. So that leads me to believe that the IDA does not have the authority to give that, and it's got to come back to us to provide the pilot. Can you help me resolve that confusion?
First of all, that was an earlier one that we gave you, and we since had council clarify that. And it was in that clarification that council gave us, that it becomes a matter of who owns the land. So going back to the example, so IDA improves product, and company comes along and says, okay, we want to buy that land, okay? So when they buy that land, it's no longer within the control of the IDA, which is a public body, and so then it becomes, they come before you. Now, the IDA, which is a public body, if the land is staying in and someone says, okay, we're gonna do a build-to-suit lease back, okay? We can do that. The IDA can do that. We had council clarify that. That was even a question I had, because I needed to make sure I was clear on Arkansas law. And so we can do that, and that's what we would do, but still the taxing bodies are gonna get, they're gonna get paid, you know, based on the negotiation. It's non-abatement though, let's be very clear on that.
Yeah, I see your example, not really a pilot, right? Maybe I'm wrong, but we're not taking payment in lieu of taxes. Because you own it and you're leasing, leasing it back to them, they may get some advantages from that. But I don't know that they're getting tax advantages, are they?
So remember, payment in lieu of taxes is not a guarantee. It is a case-by-case situation, okay? There's this assumption that it's gonna happen on every deal. Payment in lieu of tax agreements are just that, it's a negotiation. And that's when it's asked for, but it's not always asked for. I know there are some that believe that every company out there is gonna ask for it and it's a given, and I know there is a strong sentiment about, okay, so bonding and payment in lieu of taxes, these two things are separate, but you know, when you get into payment in lieu of taxes, it starts to smack of an incentive, okay? And I want to separate that. Just so you know, within my own industry, I take some grief because I would probably be the closest thing to an economic developer that doesn't really strongly believe in incentives. There's financing mechanisms, and then there are incentives. And unfortunately, incentives used to be a rarity. Incentives used to be something like, if you had two dominoes standing there and you want to make the domino fall your way, that was like a little incentive to get it. But now incentives have become egregious. You read about them in the paper all the time. It basically states buying a project. That is not my personal philosophy. And so payment in lieu of taxes, coming back to it, Justice Lyons, is not a given. It is a case-by-case basis, and the ownership of the land will determine who decides that.
Okay, I think, I'm not gonna belabor it here, but I think we need to work on that. I pulled up the regional, what was this? It was one of them, JP Ecke sent us, Regional IDA formal briefing packet, updated final, 10825.
Okay.
And it still leads me to believe that any of those agreements have to come back in front of the quorum court. So we can work on that, but
So
there's a confusion factor there.
Okay, I can have our council, we
that's
have a
fine.
memorandum already on that.
That's fine.
We can get that settled, but again, it comes back to who owns the land, that's all.
Okay, just in interest of time.
Yes.
We'll move on, but we'll look at that. The other confusion I have is, we've heard a lot, there's no risk to the county. I think you and I talked, and I think one of the items came up in the Benton County Quorum Court was there's no risk to the county, but plenty of upside for the county, right? I believe that's one of the JPs there said that. But again, as I was reading through the items that was provided this week, and I don't remember which one, I apologize. It talked about if a locale separated from the IDA, they're responsible for paying back their part of the debt,
Which there's none. One, we've not asked you for any.
which there is now. Okay, then that was, just because it was in there, it led to the question of what did that really mean, right?
Right.
Okay. So there would be no debt. So again, there is truly no risk to the county.
That's correct, because we're not asking you to put
Okay.
anything into it. Yep.
It caused a.
Nope, great question,
Confusion.
no. That's why we're having this discussion.
The templates that were in here, or the draft templates, did they, and I think you said this right, I think I missed it, I couldn't hear it. Where did those come from? Were those created by you guys, the council?
Drafted by our council.
By the council. You drafted those based on state input, there's 5 or 6 locations in here you talked about that's already doing this, pull in things that they were doing. What was the basis for those drafts?
So the basis for drafts were based on both what was required in Act 576 as far as ordinances, bylaws, and
Okay.
operating agreement, but then we also looked at some other states that use regional IDAs, and we looked at some of their language.
Okay.
So just so we had a perspective of,
Yeah.
were we just looking at Arkansas, or we were kind of looking at it broadly at other states? Like Virginia, if you look at their economic development performance, very well. Top performer in the last couple of years, they've literally broken to the top 10 category of everything. And they are also the ones that are most leading the charge on regional economic development for IDAs.
Okay.
So we wanted to make sure we were applying Arkansas law, but we also wanted to make sure we were looking at best practice.
That was my assumption, but I appreciate the clarification. Thank you.
Justice Bruns.
Thank you. I have, in the past, done quite a bit of development.
We talked about that, yeah.
Yeah, when you and I met, we talked about all that stuff. And it ends up, it's all about money. Development's all about somebody getting paid, somebody making money somewhere. And so I'm curious, I heard you say that it wouldn't cost the county any money for the project, correct?
Correct.
There'd be grants for that, is that?
Grants, but also as the authority makes money, it doesn't pay, it's not like a corporation that pays a dividend out. It takes that income and reapplies it into the next development. So when the next development opportunity comes along, we have the money to put into it.
So they do an ROI, basically, yeah.
Yeah, return on investment.
So you got that entity. What about your personnel and salary and your facilities and stuff like that? How is that paid for until you get a project?
Okay, great question. So in the next version of the draft operating agreement, what we're going to do is it will be 2 people. It will be myself, if the board, and remember the board, if you approve it all, 3 counties are going to report their board members, and the board members will hire the executive director.
I'm sorry?
So, I'm sorry.
If you'll speak into the mic,
Yeah.
it really helps. Bring
Sorry.
it down closer.
If the 3 counties all authorize it, and you appoint your board members, okay, the board members will then be responsible for hiring the executive director. Okay, so if that is me, that's not a given, because the IDA hasn't been founded yet, and the board hasn't been created. But if that's me, right now what we envision, it will be a staff of 2 in the beginning. There is no reason to go out and get your own office space. What we've got is an agreement with the Northwest Arkansas Council that we will do a shared services agreement so that we're using their back office, their payroll, their human resources for the first couple of years till the board of the IDA feels like it's financially able to go on its own, so to speak. So it's kind of like a startup. You are judicious with your money and your funds, and that's the way we intend to have the IDA operate. So instead of going out and doing everything, recreating all the systems ourselves.
Okay, so the county, Washington County, would not be responsible for any of your salaries or
That's correct.
anything? Okay.
That's correct.
All right. Now, I did hear you say something, and please correct me if I'm wrong. I thought I heard you say that, you know, if you go out here and you do let's say a project that's 10 acres, okay?
Okay.
And you have basically got a CPU for that acreage that says you can build a factory on it, and then all of a sudden you go out on the other side and you all build apartments because you've got your CUP to build it for differently than residential and/or agriculture, which is what our restrictions are. Then, do you all have any internal saying that you're just going to try to turn over that 3 acres, whatever it is, for this project, and then go to the next project and get another CUP?
We are going to abide by whatever the zoning, the planning process and regulations are.
That's what I'm saying.
We are about industrial and technology development. So I'm not sure I was following you, but I think you were asking like, well, first of all, I don't ever envision us having a project as small as 10 acres, but I understand you were using an example. But if I understood you, I think you were saying, well, what if you did what you were approved to do, and you did it on 7 acres, and now you've got a remaining 3? Would you use that remaining 3 for some other alternative purpose? And that would not. Is that what was I understanding you?
It would still fit the CUP because all the CUP is basically doing, unless the attorney tells me differently, says that you don't have to make it residential and you don't have to make it agriculture.
I would simply say that whatever we are approved to do, that's what we're going to stick to. And like I said, the authority has a strict mandate. It's going to do X. Mm-hmm. And we're not going to verify out of it. It'd be like X&A saying, well, you know, for all these years, decades, we've run in an airport, but we decided now we're going to do this. It's the same thing with the Industrial Development Authority. We have a strict mandate, and we're going to stay in that. And whatever you approve, if we bring a opportunity, a project to planning and zoning, and they say you are approved to do X, that is what we're going to do, and we're not going to deviate from it. Because that's what we've been approved to do.
Mm-hmm. Okay, this whole project sounds to me like that you're sort of like and again, I don't know your organization that well, so just from what you and I talked about, but it sounds like a facilities board for a chamber. Are you going to, And do you have any experience with y'all working with a chamber that we can follow up on?
Sure. Well, yes, if you want to follow up on the Northwest Arkansas Council, like I said, we have a over 10-year agreement with all the chambers throughout Northwest Arkansas.
good.
You can ask how we perform as a partner,
Good.
as a collaborator, all of that.
Yeah.
You can't ask, well, how would the IDA, because the IDA doesn't exist yet. But yes, you could call anybody and they will tell you how we all work together.
Well, that's all I wanted to know, because everything everybody was asking was sounding to me like we were headed to a facilities board, and most big cities already have a facilities board. And they run it through their chamber. And I, for one, don't want to see y'all competing.
That's just the point. So there isn't a competition, because what we're doing at a regional level is we're looking at projects that either the private sector or even a local chamber would not undertake in and of itself. It has to meet, for the IDA to do that project, it has to meet the threshold. Is it extremely impactful, and is it transformational? And not only will it benefit the local, but does it benefit the entire region? Otherwise, there's no reason for us to do it. And so when you look at a local chamber or city and their facilities board, that meets the local content, but that doesn't meet, does it make the whole region blossom? Does it impact the entire region? So that's the whole reason we're proposing a regional industrial development and technology authority, is to go beyond just looking myopically at communities and saying, can we do something as an organization that not only does benefit the community, it benefits the county and it benefits the 3 county. If it meets those criteria, we will do it. If it doesn't meet those bars, there's no reason for us to do it.
And we could write all this in prior to signing?
Sure.
Okay.
Yeah.
I have Justice Lemming.
Thank you, Lisa. Whew. I've heard tell of, like, I know what you're saying, a big deal. I've heard tell like Boeing wants to build a big plant up by the X&A. And that's the type of facility you're talking about bringing to Northwest Arkansas. It'd cover hundreds of acres, and it'd be a monstrous deal they would have all the buildings and all the glory up there, and Washington County would probably be able to send some employees to get employees up there. So to benefit for one or the other would be better or less. So question to you, if you set the IDA board up and you get your 3 members from Washington County, 3 members from Benton County, 1 member from Madison County, who's going to set your salary in this game? Is it going to be the board? Is it going to be
the board?
The board, the 6 people, the 7 people.
Right.
Once that board's formed, once you get your authority, what authority's left to the Quorum Court? There is none, the way I read it and see. Is that correct?
Directly, yes, because quorum courts don't manage organizations, but your representatives do.
So, and I seen in there also, if, say, like we have a representative that is appointed on that board and they move to California, the way I read it, they could still be on that board. Is that correct?
Well, that's why that's one of the amendments that was put into the agreement, because, yeah, there wasn't a removal clause in the original old legislation. So that's the amendment that was added in that allows you to do that.
When you say old legislation, how many times has this been going so far? I mean, you're just now getting started, is that correct?
What I'm saying is, as I said earlier, the original legislation was what enabled the ports in Arkansas to do. They are industrial development authorities. They're just called ports, but they have the same abilities.
So you're saying you went off the paperwork was started in 1960?
Yes, but then we expanded it to, we expanded the use in that But one of the things we didn't see was that there wasn't a removal clause. So that's why we put the amendment in the Benton one, so that there is a way to remove somebody until we open up Act 576 and insert the fix.
Okay, so once your IDA is set up and once your board's set up, tell this quorum court what powers any of us have left and tell us what your powers are and what you can do, and we have nothing to do with.
Well, you have the power to appoint the board members, and when they're.
Well, you said earlier the judge was gonna tell us who we could appoint. So does the quorum court appoint him or does the judge appoint him?
The judge appoints, but.
We approve.
You approve. Okay, and that's gonna occur, well, that's the way it was explained to me, and that's. Go ahead. So I see people shaking heads. So if Judge Deacons presents a slate of people, you guys don't have any say in it? Is that what everyone's shaking their heads?
He does whenever he does the committee meeting, he does for like Washington Water Authority and stuff that's involved in Washington County. He wouldn't have no authority to do anything in Benton County.
Well, it's not, it's.
But I want him to explain to us what this authority does. That's what I want. Your power and what you can do and what we can't do. And what our people, just like you're talking about, I think what you're talking about on this stuff about our CUP and our zoning, I think that crap's out the window because I think you're working above us and working with the state of Arkansas, and you can go over us. If I read it right and see it right. You talk a big story, but I don't think by law, if you form your IDA, I think you can do whatever the heck you want to.
Okay, well, that is.
Explain it, tell me why I don't feel that way.
Well, because I don't have the statute with me right now, but I provided the Madison County Court because they had the same question.
This is Washington County Court.
I understand that, sir.
Well, give it to us.
Okay, let's be respectful. Just ask the question and.
I did not bring that with you, but I can provide it for you, sir, tomorrow. But there is legislation in Arkansas that says if a county or municipality has zoning and planning regulations in place, the IDA is responsible for abiding by those and working through that process. And I will send that to Justice Ecke tomorrow, and she can share it with you.
I would greatly appreciate that.
I will do that.
As will the rest of the court. Justice, let me cue your mic again, please.
I don't believe it needs to go to Ms. Ecke until it goes to our county attorney first to give us his opinion, because he's the one that's supposed to take care of us. That's the way I would see it.
Well, then, Justice Ecke, will you provide it to your county council?
I will.
Okay. And if there's a disagreement in the way we understand the law, and we've gotten it from our council, two councils can do what councils do. But this insinuation that somehow we're above, just because we're created as a separate public body within the state of Arkansas, this idea that we're somehow above everything and that we don't cooperate and we don't follow policy and procedure and follow law is just that is not correct. Okay?
Okay, I have Justice Coger. Robert Dennis is next.
I thought J.P. Rivera Lopez was before me.
I had asked because I'm making comments.
Oh, okay. Okay, thank you. Let me get to my notes here that I've been taking. And this is my opinion, but this act that we're looking at, Act 61, in my opinion, it grants almost limitless power to the authority. The only thing I read that you cannot do is condemn a public utility system. We talk about guardrails. Well, they can be ripped away by a court of competent jurisdiction. And I do not agree that the authority has a strict mandate. It grants labor policy decisions to the authority. The authority is governed by its board of directors, not the quorum court. I don't want a severability clause because that could wipe out any amendments that we do make. And I heard what you said about eminent domain may be taken out, but we don't have a guarantee that eminent domain is going to be taken out. There's no guarantee of that. If Washington County taxpayers are going to subsidize industries like with the pilot and tax abatements, I want those decisions made here in this court, not by anyone else. The act also, I want to point this out, gives the federal government a lot of power. It even says that the federal government condemns property, the authority will pay the judgment. Condemnation decisions by the federal government should be federal accountability and funding, not the local authority. There's also a provision that allows the federal government or any of its agencies to take over authority facilities. The authority can set their own bylaws and rules, decide who gets help, decide who does not get help. They can change the rules and bylaws on their own. It's like whoever wrote this act just threw everything in that they could think of, thinking that the legislature might take some of it out, but evidently they didn't. Will it be subject to the Arkansas Freedom of Information Act?
Yes.
Absolutely.
Mostly, this is going to impact rural Washington County because there's not much space left in Fayetteville and Springdale for industrial development. And it's very expensive. So I see this affecting mostly rural Washington County. And I don't want Benton County or Madison County making a decision about Washington County. So if we appoint 3 members, Madison County appoints 1, and Benton County appoints 3, then Benton County and Madison County, that's 4 votes. They'd have authority over whatever happened here. I'm also fearful that this is going to bring a data center. We do not want a data center in Washington County.
Nor do we anywhere in the region.
I'm sorry?
Nor do we anywhere in the region.
Well, can you promise me that won't come?
That could be one of the side rails.
That can be a guardrail, but
Guardrails can be wiped away.
So, I can't say when it's gonna be published, but we're interviewed, myself and Nelson Peacock, the president and CEO of the council. We were just interviewed and asked what is Northwest Arkansas's position on data centers? And we said that basically from an infrastructure standpoint, it would cripple our region because of the amount of energy they use. And we do not advocate for them as a region when companies come to try to bring them here to Northwest Arkansas. Northwest Arkansas Council does not even entertain them because they're just not good. They take too much energy, and depending on their technology system, if it's an older data center, they're gonna use too much water, which we are careful of. So we do not at the council advocate for data centers, and at the IDA, we would not either, because remember, it comes back to the guardrails. Our principal guardrails is it has to be high impact and transformational. Most data centers use a ton of infrastructure. Yes, they may be 200 well-paid jobs, 6 figures, and the community itself, wherever it's located, will get a lot of real estate tax, but that doesn't meet the bar of benefiting the entire region. So that would be not a project that would fall within that the IDA would ever want to do. We are not in favor of them here in Northwest Arkansas. We simply don't have the power. We are on our way as a region being 1 million people. We have to balance the ability to provide energy for industry and for all the residential growth that's gonna come. And one data center would cripple us. So most of Northwest Arkansas is serviced by the co-ops. Now there's a small portion that comes through Washington County that's directly served by SWEPCO. And I don't know if anyone pays attention, but the Co-op Association of Arkansas is only planning and building 1 gigawatt of new energy generation, which is going to have, that 1 gigawatt is gonna have to be shared by all the co-ops. One data center could take up an entire gigawatt right off the bat. There is not room in Northwest Arkansas's energy system for data centers. And that's what we have said that will be out. I don't know when the publication's coming out, but that's what we were interviewed and that's what we shared. And that's our position.
What's your position on what I said about 1 from Madison County and 3 from Benton County could overrule and decide what happens in Washington County?
Well, a board could work that way, but it could go the other way around too. What if Washington and Madison said, well, too bad Benton County. So we're getting back into parochialism and this myopic way of thinking here. The reason that's not going to happen is because we're looking at projects that meet those higher guidelines. And I know, I can see by the smiles on people's faces and stuff, but look, Northwest Arkansas is growing. The genie can't be put back in the bottle. Okay, so there's two ways you're gonna respond to growth. You're either gonna be reactive to it, which is rarely ever a good way, or you get proactive and you go out and you build what a community wants, what is gonna make sense and provide a higher value. But that's the way we're gonna get that's the way Northwest Arkansas is gonna grow here and grow well. Yeah, it's not gonna be, I think this is the same discussion that the Benton County Court started to go down about, well, we want to control how many seats we've got versus somebody else. Okay, that defeats the whole purpose of regionalism. I mean, either we are a region or we're not a region. Either we behave as one or we don't behave as one. Either we talk that we are, but then when it comes right down to it, we all just want to seek to our own. I mean, I can't tell you how you want to do your business. And if you don't, if you don't see the value in this, then you don't see the value in it. But you do have controls. Okay, yeah, you're creating another public body, and that body has a mandate to build real estate, and that's it. And there's no other higher purpose to it, no other alternative purpose to it. And you do have control. Every county judge, I know it's Judge Deakins right now, who knows what it is in the future, but every time the board appointments are done, new ones are gonna be brought on. If you think any of you listen to my conversations with the Benton County Court, we had this discussion. I said, if you're really that concerned about it, then I pleaded with him, and I'm not using that word frivolously. You will hear me say, I plead with you to make sure you give us the best board members possible. The judge is gonna bring them to you, and I know I'm using the wrong term, but it's in my mind, it's kind of like advise and consent with the Senate. You do have input, and I would hope you do. It's just, I'm saying the same thing you right now I said to the members of the Benton Quorum Court. When that time comes, help Judge Deakins, and in the future, whoever the other judges are, make sure we always get the best board members, and make sure those board members know what your mind is. Okay, we're not just appointing people for the sake of appointing people. Appoint people that see things the way you see them, that want things to happen the way you want. That way, when they're combined as a board, your will is being known.
Well, the act says that we, not the Quorum Court, not Judge Deakins, chooses the members. How I read it. Also, Madam Chair, I would like to make a motion that we postpone this item indefinitely. That's my motion.
I have a motion and a second to postpone this item indefinitely. There's no discussion, is there? Or is there discussion? Okay, if there's a...
It is debatable. If it's indefinite, it is debatable.
Thank you, Counselor Lester. Is there any discussion? Justice Dennis.
Thank you, Madam Chair. I had it written down on mine right here. It's almost the same thing, to table until the March. So I would like to amend it to specific time, March committee, county committee.
I have a motion to amend to March County Services Committee meeting. Do I have a second? I have a second from Justice Lyons. All in favor, raise your right hand.
My motion.
Hold on. We have to have discussion. Is there any discussion to the amendment?
Why are we not discussing my motion?
We did. We did.
Because this is a privileged motion. You have a main motion, And then the privilege motion is to amend the motion that you've made. So that has to be taken care of first before we go back to your main motion.
Okay.
Is there any discussion to sending it to the March County Services meeting? Is there any discussion?
I do.
Justice Dennis?
The reason I want a time specific, and correct me if I'm wrong on this, but I want it to be able to come back up. If you do it indefinitely, then you're killing it. And so I could be mistaken on what I've read and what I've understood. I'm not championing it, but I don't want to be foolish and not study it out even more. But I sat here and read a lot of things on AI using someone's electricity. And I'm not ready to make a decision tonight, so I hate for it to die. And so, but I'm also not, if I have to vote tonight, I'd vote no. So therefore, I want it to stay alive until next county services meeting. And I think that's what you have to do in order to, because indefinitely doesn't mean a direct time. And so if you put in a definite time, then it keeps it alive. We can all do our studies. There's a lot to learn on this. And so I'm trying to be fair on both ways. But if I have to vote tonight, I'll vote no. But if it goes indefinitely, that's the same as a no, the way I understand it. So that's why I made the amendment to the motion, and I welcome your discussion. Thank you.
Thank you. I have Justice Lyons.
Thank you, Madam Chair, and JP Dennis, I agree. And that's the reason I am not for postponing indefinitely, because it kills it. I'm not ready to kill it. However, I do believe we're not ready. There's a lot more questions. There's a lot of things we've heard that I'll get this to you, I'll get that to you, whatever. And I think we need those, and we need those and to understand, I mean, some of the amendments we want to bring to this based on the information being provided, right? I agree that if you're not in one of the 3 counties, you shouldn't be on the board. That's it, period, right? And that's not addressed, right? Although I think Benson County did address it. Could be others out there. So that's why I am in favor of the amendment to postpone until the next county services committee is what, I think that's what you said, right? Correct?
Thank you. I have Justice Lopez.
Thank you, Chair. I had been wanting to make a couple of comments on this, and perhaps being in a different stage in my life, I see a lot of the benefits in this. As I've come out of high school and gone to college, and I had friends who left to find opportunities in
Point of order.
By all means.
Justice Wilson, can you cue up your mic, please? Justice Wilson, what is your point of order?
I have no objection to hearing any colleagues' thoughts on this issue. But I question whether his thoughts right now are germane to the motion that's being considered.
Yeah, absolutely. I will make an effort. I am making it germane to the issue of postponing, why I am not in favor of it. I was just trying to provide my justification as to why I was not in
As
favor.
to why you're not in favor of it?
Yes, in postponing.
Okay, make
am
the
I allowed to
motion while
continue?
you're not- yes, please continue.
Okay, absolutely. And for that very reason, in that very same nature, I do believe that it is prudent for us not to kill something, because we need to come to a decision at some point. To parrot some of the same things that have been said, growth is going to come whether we like it or not. The northern corridor of Highway 612 is going to happen whether we like it or not. That is not something that is within the control of this body. Whether we like it or not, there are going to be things that are going to lead to development, and it is going to grow. But I do think that it is prudent of us not to delay making decisions on things like this indefinitely. If people need more time to be more informed on the decision that they're making, absolutely. that is a different discussion. But to kill something when it may provide jobs that are meaningful or opportunity that is meaningful, I don't believe is the right course of action for this body or for anybody. I was going to support this tonight. I will support it in the future. I continue to believe that it is meaningful to be proactive about how we view development in our county. And if the only way to hear this is to postpone until March, I'll support that as well. Thank you.
Is there any more discussion? We ready to vote? I have a motion and a second to postpone this discussion, or to amend, thank you, the discussion till March County Services meeting, correct?
Yes, except for the fact that if there's no snow, then you put a date, does that make it, another snowstorm or something that causes the date to change? If you put a per date, I'm asking the county judge that.
You need a mic up, please. Justice Dennis,
You quoted it as being a date specific.
wasn't that the amended motion to forward it to the March, to postpone it until the March County Services meeting, correct?
Correct, is what I said, not the date. Because if you say the 12th, then it's,
No, I didn't say the 12th, I thought I said
Okay, I
the
thought
March
you did.
County
Okay.
Services meeting,
All
because
right.
we're not on the 12th.
yes.
We're on the first. That's this month. Okay.
I'm
Are we
just-
clear on the motion and the amendment? All in favor, say aye and raise your right hand. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. All opposed? The motion passes. So now this discussion will be, no? Or back to the main motion. And there's a motion to postpone to March, to the March meeting, County Services meeting. All in favor? No? Is there any more discussion? Whether you are in favor or opposed to the motion that this will go to the County Services March meeting. That was the amendment. That was to amend, and now this is a main motion, and we have to vote on it. It's like it's, yes. Yes. After you amend a motion, you have to then vote on the main motion, okay? Is there any discussion? No public comment. All in favor, raise your right hand.
What are we voting on? I'm sorry.
The
main motion.
The main motion,
My motion to postpone indefinitely.
no. It was amended.
Yes.
So what happened to my motion?
It was amended.
Your motion was amended, so now the main motion on the floor is a motion to postpone until the March the March County Services meeting. And that was the main motion brought by Justice Coger and was seconded by Justice Massengill, correct? So that's what's on the floor is a motion to postpone until the March County Services meeting.
All in favor, raise your right hand.
Okay. Those opposed?
All opposed? We have 2.
Passes.
The motion passes. Further discussion.
No, that's it. We'll move on.
We're moving on. Just a moment. Okay.
Okay, my point of order goes back to an earlier item that we have that I've been getting questions about. So on the Gully Park thing, why did we not have to, how did it move on to the full quorum court on its first reading?
It's not on a reading.
It's not on a reading.
What?
Hold on.
I'm sorry.
It's not on a reading. It'll be on its first reading at the quorum court meeting. The readings don't occur at committee meetings.
Okay, thank you.
You're welcome.
I feel better.
Is there any public comment? Good evening.
Good evening. Nikki Lockett at 12283 Greasy Valley in Prairie Grove, and Justice Ricker is my JP. And it's been several months since I've gotten up here to talk to you all about the wind turbine situation, but I haven't gone away. So I did attend the hearing, the Arkansas Public Services Commission hearing in Little Rock in December, and it was really wonderful, and I'm glad I went. One thing I want the community of Washington County to be aware of, and we would really love to see you all come out to this event. We're having a community event on Monday, February the 23rd at the Lincoln Community Center in Lincoln, Arkansas, right on the square. It's a beautiful facility. And we're going to have guest speakers of the concerned citizens of the Ozark, and they are going to cover Act 945 and also give updates about what's happened since the hearing in Little Rock. And they want to discuss, or they're going to cover where there are weaknesses in Act 945 and how a county ordinance could close the gaps on those weaknesses of the act. And so we're asking everybody to arrive by 6 p.m. The presentation will start at 6:30 p.m. We will have time for question and answers after the presentation, and we plan on being wrapped up by 8 o'clock p.m. Would love to see you all come out. And then just one note, this was really, really interesting tonight. I just wanted to make a point. I really do appreciate, I think you all do your diligence. And I've watched some other county committee meetings happen throughout the state and other areas, and I just really want to appreciate all of you all. But I do want to say, as a voter of Washington County, I vote to elect people who will represent me on the court, which is you all. I don't support a separate governing body that's not elected by the people that make decisions for things that will impact people in the county. Thank you. It's Monday, February the 23rd, 6 p.m., and then presentation starts, and we will have light refreshments. So,
Nikki, will you do us a favor? Can you email us
Sure.
the information?
Absolutely.
To the quorum court,
Yep.
and that way we can get it.
And I'll be sending a press release to the local papers as well. So, thank you.
Okay, thank you. Public comment. Good evening,
Good
sir.
evening, County Services. Bryson Awesome, resident of Fayetteville, Arkansas. I want to echo the sentiments in saying that tonight you all did a really good job of questioning and making sure that development within the region doesn't get out of the hands of the people that we elect to serve us. I would also like to say we would, or like to request as soon as possible, a full update on the COVID mitigation project, and also any monies that have been spent on the CAP program, CRI, and a kind of a full overview of what we're doing in terms of law enforcement in the county. Thank you.
Thank you. Is any other public comment? Seeing that there's none, this meeting is adjourned.